Yeah, I'm on. I'm gonna turn my video off.
Morning, everybody.
Morning.
I don't know if
Okay.
Good morning.
good morning. Would you want to go ahead and do a call at the facility to see who we have?
Vernon Smith.
4 hours.
Vernon Smith is on.
Yeah.
Right here, so I got it right here. I got it.
Oh, thank you.
And I shouldn't say that,
No,
but I did.
we have to love.
I got it right here for you.
Rachel knows I am not my mother-in-law. I went one time to Tennessee and I made my husband come pick me up. I did. I cried. I said, I can't do it. I can't go back.
You said I love to spend a day in this game.
I did. She fussed about the horses the entire time, the whole trip up there. And I'm like, if you're going to do this the whole time, I can't deal with it.
I can't imagine having her as a mother-in-law. I love her, but
I love her.
she's a great woman.
You don't have to lie to me. I know she is a
very
weird, odd person.
Stern lady and
Okay,
gets mad.
we're streaming, y'all.
Yes.
We're streaming.
Okay, y'all are on YouTube, okay?
Delete everything I just said. Anyways.
So Alyssa's speaking, but I don't know.
No, she's on the phone.
She's just on the phone.
Yeah.
I put my husband in a very
Uh,
bad
What I was doing, Hector, I'm speaking with Latoya at GSP and we're going over the list for them.
Oh, okay. Gotcha.
I got a question, Hector. Mr. Darvell McFarland, I'm showing that he was continued.
That's, Rachel and Renee are gonna be at the controls today. I'm actually, I'm gonna have to leave shortly, so that's Rachel.
Okay.
Celissa, who'd you ask about?
I'm actually on the phone with GSP, and Latoya is saying that Darvell McFarland is continued. Is that true?
Yes, that is correct. That is
Okay.
continued.
Okay, and I have. Okay, thank you, Rachel. I'm gonna go finish. What about Michael Rivers?
Michael Rivers is continued as well.
Okay, so,
Yes,
and Frankie Gephardt.
that one is continued as well.
Okay, so I'm going to, she's gonna take those three back.
Okay, that'll work.
Mr. Groove's on.
Okay, so for GSP, Rachel, we have Lorenzo Wells, Jack Cruz,
Mm-hmm.
and Victor Callahan.
Victor Callahan and Lorenzo Wells do not have a hearing. They're
Okay,
continued.
well, you, on that, the last, update that you sent me with Lorenzo Wells, he was on there for Georgia State Prison. So you want me to remove him as well?
That's right, but I got a call from his attorney yesterday, so he's continued.
Okay, so GSP only have one, right?
Um,
And that would be Jack Cruz.
that is correct.
Okay, thank you, Rachel.
You're welcome. Yeah, the
I'm
rest
gonna
are
do the same thing for
Smiths.
Smith.
Okay.
Okay. Who's going first?
Henderson's going first, number 7. And Burleson, number 1's going last.
Okay.
That's all I know.
Hey, Groove.
No.
Me and Renee were worried about if somebody can't connect, how to tell them to connect back on.
Oh, yes. You, if they're having video trouble and they're cutting out, all you do is you click the arrow button right next to the mute,
You gotta, Rachel,
and then you gotta switch audio,
Yes, ma'am?
and then
you ready to do the one for
call
Smith?
in right here to view, and then they have all this stuff.
I know we have 2 requests on order. We need to do Henderson first
Okay.
from Smith.
What about Robert Rolliston? Is he
Because
still
Rachel's gonna
relevant
handle that
today?
part.
Okay.
As far as.
Yes, but we want to call that case last.
Okay, Robert Rolliston is there. He's supposed to be there.
Okay,
Robert
And
Rolliston.
everything changes.
That's
It depends on the person, so they
Yeah.
can't give that code because otherwise
Oh,
it'll
okay.
think this computer is the one that's calling in.
Okay.
So the code is the code. And
That and then
Rachel.
follow instructions.
Yes, ma'am.
So just go up.
I see you have Robert
Down
Rolliston
arrow
on
button.
the, on that list that you sent me. I don't think I don't think
Oh.
Smith ever received that
Okay.
on the initial order.
Thank you.
oh,
I don't need.
okay.
We're gonna try to get him. Robert, do you have his GDC number by chance?
Yes,
Can I get that?
it's 100
Okay.
143
Uh-huh.
4358.
4358.
Yes, ma'am.
It's not his
Okay,
name.
100 143 4358.
That's correct.
Okay, and what about
Make the
Demario
first
Goodrum?
witness a panelist.
Goodrum, it got
If you know who the
continued
first
as
case
well.
is, I would
Okay,
just go ahead
Demario
and
Goodrum is
get
continued.
ready for the judge.
You heard me, Ms. Nair? Okay, Jonathan Johnson.
No, that's gonna be Paula, right? Is that?
Where's she
I
at?
don't have him on
I
my.
haven't seen her. That's the issue.
Yeah.
Catherine Mouse was his attorney. Oh, it was
He got-
continued.
I'm just gonna
It
keep
was continued.
refreshing when it
I-
says, you know, when it gives me an
Jonathan
extra.
Johnson is continued. Brian Weldon, we need him.
That's right.
Brian Weldon. Rachel, what's Brian Weldon's GDC number? Because we don't have, I see him on your list, but he wasn't on the original request. So we don't have him on from Smith. So what is Brian Weldon's GDC number?
It's 1,000 159 078.
So you said 1,000 159 078.
That's right.
Okay, and so we're gonna have to go get Weldon and Rollinson. And then we're gonna go down the list. And Michael Stallworth,
That one's removed from the calendar.
I said,
No
oh,
hearing.
he's not there. So what about Bingham?
He's got a hearing.
Do you have William, Miss Snell? You don't have Baruch William? Baruch William. Baruch William. What is his GDC number, Rachel?
Hold on. It is 129
Mhm.
0162.
Binyam, Barack Binyam. That's his name. And his GDC number is 1290162. And Brandon Leonard, do you have Brandon Leonard? Quantarius Henderson, Jamars Jackson. Oh, that's continued. Yeah, just continued. Jamars Jackson, you don't need him. And that's it. So we need 3. Who? Oh yeah, Jamie Worthy. Yeah, we got him. So we need those 3. So Rachel, we're gonna be holding on Rollinson, Weldon, and Benjamin until he gets them up. I was out yesterday due to emergency in my family, so I wasn't able to check the list yesterday. So I'm checking it this morning, and so she's gonna get those 3 up, and she has everybody else on your list.
All right, that's fine, because Rollison needs to go last anyway, so.
Okay, she said Rollinson gonna be last anyway, so we'll need Rollinson, Weldon, and Benjamin. Okay, I'm sorry about that. Okay.
All right, thank you. Renee?
I can't find Paula.
Send them a list of who I need.
Huh?
Just so y'all know, Paula is listed as an attendee and not a panelist. Yeah, I'm not sure how to fix that. Her username is UU though.
Name's not on there. I think
Okay.
she's the undefined.
Is she undefined?
She may be
Yes,
just,
undefined.
Okay.
okay, there you go. I'm sorry, her name didn't appear, so we usually, once we see the name, we'll
Okay.
transfer them over. Apologize for that oversight.
Yeah, we didn't know who that was.
We're standing up.
Miss Paul, there you go. We see you now. Okay. All right. You good?
I'm gonna try this. No, not really. Well, no, I don't. I can't unless your name is. Oh, okay. Yeah. Well, I can walk that way. Look. Do you want-
I made Paula present.
Yeah,
Okay.
yeah. Well, once you made her a presenter though, it takes away from Eric.
Oh, got it.
Oh, okay.
Whoever, is the one going to be presenting the case, I think you should go ahead and just make that person the presenter. whether it's
Okay.
Eric or Paul.
Yeah. Okay, Paula's first, so
Okay.
she's the
Yeah,
thingy.
yeah.
Okay.
Right here, Rachel, I was telling her name, in order to do that, I'm sorry.
No, you're fine.
Just the down arrow beside the unmute button. Click it. And then you're gonna click,
Switch audio.
and then once you click it, this menu pops up. And then you switch audio. And then once, there's a view button right beside calling, click that, and then that's the instructions.
Okay, and that's what they see on there.
That's what they're seeing there. So
Okay.
I
down
forgot to put
arrow,
switch audio.
switch audio, call in, and then view.
Y'all let me know when you're ready. No rush, just.
Yes, sir.
Okay.
Okay, I think I got it.
All right,
Okay, I think so, yeah.
all right. Tracy's here, or call me out.
Yeah.
Thank you, Hector. You're a big help. Huge, big help.
Good morning, how are you? Good.
In-law duty today,
That's
so
good.
What, That's what I remember.
I think we're ready for Henderson to go first, Jim.
Okay, yeah.
Good morning.
Good morning, nice to see you over there behind the monitor.
I know I'm hiding.
There you go.
Morning, just making sure you can hear me.
Like clear as a bell, how are you?
I'm good, Judge. How are you?
I'm fine.
How's everybody?
So far, so good. I'm happy to say, so far, so good. All right, we ready on Henderson? I understand we wanted to go forward with that first. Is Mr. Henderson available?
Is that Mr. Henderson at Smith?
It should be. Yes, it is.
Okay, let's go ahead and bring Mr. Henderson in. And it's my understanding Mr. Henderson has, okay, he is pro se, is that right?
Yes, Your Honor.
All right, I just don't see, I see me twice and I don't see Mr. Henderson at all. So as soon as we,
Is that him right there?
all right, there he is. For some reason, I've got a different, okay. There he is. I need to change the layout on this monitor. All right, are you Mr. Henderson?
Yes, sir.
Good morning, how are you?
I'm doing all right.
All right, court will call the case at this time of Quantarius Henderson versus Brian Adams. Warden case number 2028 C28 JS. And Mr. Henderson's here. And is this Mr. Smith's case?
This is Paul.
I mean, I'm sorry.
Yeah.
Yes, this.
We have a witness in, I'm sorry, Judge. We have a witness in this case, Mr. Carr.
Is he online available?
Yes.
I'm here.
Your Honor.
I see him there. All right. Ms. Smith, if you would give a brief outline of the allegations contained in the petition.
I will, Your Honor. Mr. Henderson is challenging his convictions for voluntary manslaughter reduced from malice murder and possession of a firearm during the commission of a felony. He entered an offered plea to these charges in June 2016. He's raised two general grounds. One alleges that his guilty plea was not knowing and voluntarily entered. There are no specifics as to that. The other ground is a claim that he received ineffective assistance of counsel because counsel did not meaningfully investigate the case prior to advising Mr. Henderson to plead guilty. Counsel didn't advise him of the nature of the charges and did not advise him of the consequences of the guilty plea. We do have counsel here, and we do have the plea transcript and a couple of documents from the criminal case, which are the indictment, sentence, and plea sheet.
All right, thank you, Ms. Smith. And Mr. Henderson, are you ready to proceed?
No, sir. Due to the prison allow me to go to law library, I haven't been able to prepare my case since January. I have only been to law library one time since January, so I'm trying to see can I get a continuance till I can get my brief together and my argument.
All right, Ms. Smith, your response to that motion?
Your Honor, this case has been pending for nearly a year, and I know there have been hardships because of COVID and an inability to move around the prison because of that. By the same token, had Mr. Henderson, filed a motion to continue, we would have accommodated that. And the plus side is the witness has not had to travel to be present. It was continued last time because counsel was not here. And so under the circumstances, I don't oppose a continuance. I think for one more time to give Mr. Henderson a little more opportunity, given the conclusory nature of his claims anyway.
Mr. Henderson, Ms. Smith indicated that she has no objection to continuing your case. I'm going to continue with this one more time. You'll be notified when the case is rescheduled for hearing, and we'll go forward on that next scheduled date. Okay?
Yes, sir.
All right, thank you, Mr. Henderson.
Well,
All right, Your Honor, may I be excused?
Thank you. I appreciate you virtually being here.
Yes, sir, and I'll accommodate y'all however I may. Y'all just let me know.
Thank you very much.
Thank you. Thank you, Ms. Smith.
Thank you, Mr. Carr. And under the circumstances, we'll be in touch.
All right, thank you, ma'am. Y'all have a good day.
All right, Ms. Smith, is there any particular order that you want to proceed as far as the moving forward on the calendar?
I think Mr. Peters is going to handle the next two cases that would need to be in terms of priority. We have one witness in the Worthy case, and then we have opposing counsel and a witness in the Benjamin case. And the Benjamin case might ultimately be a little shorter, I think, but I'll let Mr. Peters make that call.
Can you hear me, Judge?
I can. Good morning.
Good morning. I have no preference. It's up to you. Maybe if we go ahead, maybe Benjamin first, since we have opposing counsel here, we can get out of the way.
Your Honor, if I can make an announcement, Mr. Benjamin is on his way up.
Okay.
We have Worthy up here if you want to continue with him.
Yeah, we can go ahead with Worthy.
Jamie Worthy.
And we do have a witness in that case, Ryan Locke.
I just made him a panelist.
Okay.
Is this Mr. Worthy?
Yes, sir.
All right, good morning, sir. How are you?
Good morning.
This is Jamie B. Worthy Sr. as petitioner.
Yes, sir. Yes, sir.
Versus Brian Adams, case number 2021 HC1. Mr. Worthy, are you ready to proceed this morning?
Yes, sir.
Okay, and Mr. Peters is here for the respondent. Are you ready to proceed?
Yes, Your Honor.
All right, Mr. Peters, if you would give a brief outline of the allegations contained in the petition.
Yes. Mr. Worthy is challenging his July 2018 Floyd County jury trial convictions for robbery and aggravated assault. These convictions were affirmed on appeal in Worthy v. State, and that's number A19A2317, Georgia Court of Appeals case out of 2020, and that was unpublished. In his petition, petitioner is raising three grounds. Ground one is that there was a void indictment because the dates in the indictment did not match the dates in the police report. Ground two was that the trial court erred in not giving a lesser included offense instruction. He did not specify which instruction the trial court allegedly failed to give. And then in ground three, he alleges both ineffective assistance of trial counsel and appellate counsel. With regard to trial counsel, he alleges the trial counsel is ineffective in 5 ways. Number one, for not filing a motion to suppress the T-shirt and the Adidas shoes that did not have the victim's blood on them. Number two, for not calling alibi witnesses. Number three, trial counsel is ineffective in failing to prepare with him. 4, that he failed to file a general demurrer. And 5, that he failed to ask for a lesser included offense on the robbery charge. Under ground 3, he also alleges ineffective assistance of appellate counsel. And he says that appellate counsel was ineffective in failing to raise the before mentioned trial counsel ineffective claims. And in support of our position, we have 7 exhibits to introduce. Yes.
All right. Mr. Worthy, witnesses that you intend to call?
I had 4 grounds, sir, Your Honor, sir. I didn't have 3 grounds. I had 4 grounds. The last and the 4th ground is lack of probable cause.
Oh, I do see that now, Your Honor. That is correct.
Okay, all right, so that's noted. Thank you, Mr. Worthy.
You're welcome.
Do you have any witnesses that you intend to call to testify?
I don't have any witnesses, however, I do have exhibits as well to support what I have to say, though.
Okay, all right, and we'll address that in just a minute. What I intend to do is allow Mr. Peters to call, I think he's got, a witness, and to conduct a direct examination of that witnesses. And at the conclusion of the direct examination, I'm gonna give you the opportunity to conduct a cross-examination. So you can ask the questions that you have. Are you willing to proceed in this manner?
Yes, sir.
All right, call your first witness.
The respondent calls Ryan Locke. Mr. Locke, can you hear me all well?
Yes, I can hear you. Can you hear me?
Yes, I can hear you.
All right, Mr. Locke, if you would raise your right hand and be sworn by the clerk, please.
Do you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Okay. Mr. Locke, first we could get some background information on you. Could you please state your name and current business address for the record?
My name's Ryan Locke. I'm a sole practitioner at Locke Law Firm. That's at 750 Piedmont Avenue Northeast. That's in Atlanta, Georgia, 30308.
Okay. And what year were you admitted to the Georgia bar, Mr. Locke?
In 2010.
Okay. And since becoming a member, how have you been employed?
I was a public defender in the Fulton County Public Defender's Office for, I think, like 2.5 years. And then I was an insurance defense lawyer for about 8 months. And then I started my own firm, and I've been practicing criminal law and personal injury law.
Okay. So at the time you represented petitioner, what percentage of your practice was devoted to criminal work?
I'd say about half.
Half? Okay. And at that time you represented petitioner, approximately how many felony trials had you handled?
I'd say maybe 7 or 8, and then a number of juvenile delinquency trials.
Okay. And how many appeals at that time?
Oh, maybe a dozen, maybe a little bit more.
Okay. With respect to your representation, Mr. Worthy, were you appointed or retained?
I was appointed.
Appointed? And at what point in the proceedings were you appointed?
I was appointed after his conviction, but before the amended motion for new trial hearing.
Okay. Okay. So did you file a skeletal? You didn't file a skeletal motion for new trial, but you filed an amended one. Is that correct?
Right. The trial counsel filed the motion for new trial within 30 days, and then I amended it, had a hearing on it, and then represented him in front of the Court of Appeals.
Okay. And do you recall which issues you raised in that amended motion for new trial?
I do.
Okay.
And if you don't mind me pulling it up so I can tell you exactly which ones.
Yeah, take your time.
Okay. Let's see. I raised a 13th juror issue, a Jackson versus Virginia issue, a merger issue. Mr. Worthy had been charged with robbery and then a number of aggravated assaults, and we believed that the aggravated assaults should have merged. And that's it.
Okay. And how did you prepare? How did you decide which issues to raise in that amended motion for new trial?
I reviewed the transcript and the filings. I talked to his trial counsel. Mr. Worthy and I exchanged a number of letters. And then I talked to him at the motion for new trial hearing. And then from that preparation, and then obviously in that preparation, I identified a number of issues. I conducted legal research and determined which ones would be the most likely to be successful, and so I raised those.
Okay. And were you successful on any of the merger claim issues you raised?
Yeah, we raised, we won on the one of the aggravated assaults merging at the trial court. And then we alleged that they should merge, the remaining aggravated assault should merge into robbery at the Court of Appeals. And so we won at the trial court, and then the remaining aggravated assault we lost in the Court of Appeals.
Okay. So just to clarify, in your preparation, did you have contact with the trial attorney?
I did.
Did you speak? Okay. And also the petitioner, you spoke with him and kind of figured out which claims to raise.
Yeah, I think he sent me 6 or 7 letters. My standard practice is when I'm appointed, I send a letter saying, please write to me and let me know which issues you want me to look into. And so he wrote me several letters after I sent him that.
Okay. Do you recall which issues you raised on appeal?
The merger issue, and I believe the Jackson versus Virginia issue.
Okay. And at that time, did you feel that those issues you raised were the most viable and meritorious on appeal?
Yes.
Okay. Now turning to the grounds of the petition. In ground 1, petitioner alleges that the indictment was void because the dates in the indictment did not match the police report. Did you see any reason to raise this issue on appeal?
No.
So there was no merit to raising the issue on appeal?
I mean, I could certainly be wrong. But in evaluating it, no, I didn't think so.
Okay. Can you please tell us why there was no merit, or why you believe there was no merit?
I mean, it's the law in Georgia that dates and indictments are not material allegations of fact unless they're made. So as long as the robbery occurred, as long as the allegations occurred during any point in the statute of limitations, then typically the indictment will survive a demurrer.
Okay. Turning to ground 2, petitioner alleges that the trial court erred in not giving a lesser included offense. He didn't specify which instruction that the trial court failed to include. Did you see any reason to raise that issue on appeal? Was there merit in that?
Again, I could always be wrong. I did not see a lesser included offense issue.
Okay. So turning to the trial counsel ineffective assistance claims, petitioner is alleging that you were ineffective in failing to raise as error on appeal that trial counsel was ineffective in failing to file a motion to suppress a T-shirt and Adidas shoes that did not have the victim's blood on them. Did you see any reason to raise this issue on appeal, or was there merit in that issue?
No, I mean the T-shirt and the shoes were obtained after a warrant search, so I couldn't find any way to say that the search was illegal.
Okay. Next, he alleges that you were ineffective in failing to raise as error on appeal. The trial counsel was ineffective in failing to call an alibi witness. Did you see any reason to raise that issue, and did you believe it was meritorious?
No. I wasn't aware that there were any alibi witnesses that were failed to be called. So I didn't. No, I didn't think about it.
Okay. Next, he alleges that you were ineffective in failing to raise that trial counsel was ineffective in failing to prepare the case with him. Did you see any reason to raise that issue? Did you believe that was meritorious?
I would have liked to. So he was represented, Mr. Worthy was represented by the public defender's office. And I believe they switched out it was Mr. Shedd who was going to try it. And then Mr. Spicer kind of came in at the last minute to try it. I talked to Mr. Spicer about it because I wanted to find something that he would have done differently in having more time to prepare. But I couldn't find anything. I couldn't find anything to allege prejudice in not having enough time to prepare or something like that to sustain an ineffective claim.
Okay. And next, you touched on this earlier, but he says you're ineffective in failing to raise the trial counsel was ineffective in failing to file a general demurrer. same question. Did you see any reason to raise that issue, or did you see any merit to that issue?
Yeah, there's always the chance that I could have missed something. I looked at the indictment and didn't see anything defective about it. But I could always be wrong about that.
Okay. Then lastly, he says you were ineffective in failing to raise on appeal that trial counsel failed to ask for a lesser included offense on the robbery charge. Did you see any reason to raise that issue?
No.
And lastly, petitioner's ground 4, he says that there was a lack of probable cause. Did you see any issues related to probable cause?
No.
Okay. That's all the questions I have for this witness, Your Honor.
All right, Mr. Worthy, do you have any questions you want to ask on cross-examination?
Yes, sir, I do.
All right,
Yes, sir, I do.
you may proceed.
Mr. Lowe. Mr. Lowe. Would you say that 4 days is an adequate time for a trial attorney to prepare for a case?
I guess it depends on the case. I mean, I wanted to find something that he would have done if he had more time, or if he would have testified in some way that he had been limited by that.
Are you aware that the trial counsel filed ineffective assistance counsel on himself for the motion of the trial? And that you became our lawyer due to that as a conflict attorney. And you and I never, ever, not one time, spoke. You said that I mailed you several letters. How many did you mail me back? None. I never heard from you. Yes, I mailed you several letters, but with no response. And you and I, we never spoke about my case, period. You already had a brief made how and what direction you was gonna go before you spoke to me. Had you spoke to me?
Mr. Worthy?
Yes, sir.
Mr. Worthy, I'm going to allow you to ask questions of the witness, and at the appropriate time, I'm going to let you tell me what you want to tell me. I'm even going to give you the opportunity to submit a brief at the conclusion of the hearing to make sure you have plenty of time to tell me what you want me to be aware of. But at this point, you're going to be limited to asking questions of this witness.
Yes, sir.
Cross-examination.
Yes, sir. Mr. Lowe, you say you spoke with Mr. Spicer, right?
I did.
He never discussed to you that when he was appointed to take my case?
No, I knew. I knew that he had been appointed shortly before, I believe the week before.
Yeah, right, the week before. And doing so, I had asked him that the police report had said that I checked into a hotel to commit this robbery. But I asked him if he could check it out, that since I had got out released from prison in February the 2nd, I actually stayed and paid every day at the same hotel. I didn't just check in that day. I was living there. I wasn't living there, but I had a room there every day. I also worked at a steel company. He failed to check that out.
All right.
It was a lot.
Mr. Worthy, you need to ask questions.
Okay, Mr. Lowe, did you and I ever verbally speak?
We spoke the day of your hearing.
The day of my, for the first time, right?
Yeah, you wrote me, I think, 6 or 7 letters, but the first time we spoke was the day of your hearing. The first time we spoke face to face or over the phone or anything like that.
Do you know, can you recite anything that I had asked you on, told you, about my case in any of the letters?
I mean, yeah, I have them here. What do you want me to do with them?
Well, I would like you to read them. I mean, because I in those letters, I think I asked you or was telling you about things that I ineffective assistant counselor. There's no way he had a time to prepare a case for me, and that alibi me giving an alibi defense and him not raising it or even subpoenaing the people, because sure, if he had it, I think I could have proven that I wasn't even there to do the robbery, that I was at my girlfriend's house.
Here, let's see, you wrote me the first letter in August 2018. And you told me that Mr. Spicer was recently appointed to your case, and you wanted me to look into that. That you got a paycheck the day before, so you didn't need any money, so you wouldn't have robbed the store. And that the DNA on the t-shirt came back not matched to you.
Right.
And
So,
a jury selection issue. Yeah.
Right. So,
You want me to?
if you had been my trial attorney, what would have been your course of action if they had evidence saying that you wore a shirt that didn't even have your DNA in it, nor the blood of the victim, that had no direct link to the case, period?
I would have presented it to the jury like Mr. Spicer did. I mean, Mr. Spicer established that the crime lab couldn't identify whose blood it was on the shirt, but they could say that it was not the victim's blood.
Nor was it my shirt. Nor my DNA. Are you aware I'm a convicted felon?
Yes.
And based on case circumstances, the DNA obtained only belonged to one individual. I'd like to submit that as evidence, as an exhibit, the DNA crime report that says that the DNA obtained in the shirt belonged to one individual. And the individual, based on case circumstances, is not eligible into the DNA database, which means that individual had never been in trouble before.
Okay.
Disqualifying my DNA from being in the shirt, because I'm a convicted felon.
Okay.
And I live at 5 Walker Drive where I was arrested, but yet after I was arrested, they went to allegedly my girlfriend's house, that they say, and got this shirt out of her trash without a warrant by intimidating her because she was on probation, telling her they would violate her probation if she didn't allow them to go into her apartment and search for things that belonged to me. And I didn't live there. I lived at 5 Walker Drive where I was arrested at. They went and got this girl off her job where she cleaned rooms at that hotel after they had arrested me. Was you aware of that?
Yes. Yeah.
So you were aware that they put a video up on Facebook, on the police Facebook, asking for the public help to identify a person by having similar clothes on to the person that committed this crime.
Yes.
And I was arrested before they actually knew that I had similar clothes by saying that they had an anonymous caller. So on the claim that I filed for lack of probable cause, they have to start with an affidavit. And they never had or never allowed or gave this anonymous caller to the magistrate judge so he could make an independent determination to whether or not the information was credible. But yet they came up with a warrant by saying my son and his mother told them that was me in the video. And if that was true, I'm pretty sure they would have subpoenaed them to court. My biological family? But that didn't happen at all. None of that's true. But yet a warrant arrives from my arrest. Why and how, I do not know. I felt I had a right to be secure in my home of an issuance of a warrant without probable cause. But you didn't see any of that as you was looking at the transcript of my case, right?
I'll let you go a good bit here, but again, if you don't have any other questions at this time, we'll move
Yeah,
on.
at this time, I don't have any other questions.
I'm sorry, sir, I couldn't understand you.
I said, yes, sir. I don't have any other questions, sir.
All right. Mr. Peters?
No further questions, Your Honor.
All right, any exhibits?
Yes, Your Honor.
Yes, sir.
Respondent has 7 exhibits, and we may have included certain exhibits that Mr. Worthy wishes to testify. So it might be a better idea if Your Honor wants to, for us to go ahead and admit our exhibits first.
Okay.
Okay. Let me see if I can share this screen with you.
While you're doing that, Mr. Worthy, the issues that you have raised in your petition require the court to go back and review the entire record of your case that ultimately resulted in your incarceration. And so these exhibits that the AG is going to tender will constitute the record. So I'm telling you that just so you'll be informed as to why these exhibits are being tendered to the court.
Can you all see this screen?
Yes.
Okay, everybody can see it. Okay. This first one is R1, and it's the unpublished Court of Appeals opinion from Mr. Worthy's appeal. So at this time, we'd like to introduce this exhibit.
All right, any objection, Mr. Worthy?
I think he's muted, Judge.
All right, can you unmute Mr. Worthy so I can ask him if he has any objection to these exhibits that are being tendered? Mr. Worthy, can you hear me? All right, for some reason, I'm not hearing Mr. Worthy.
Yes, sir. Can you hear me now?
Yes, I can hear you now. Any objection
Okay.
to this first?
Yes, sir, I object.
All right, on what grounds?
On the ground that this is for constitutional violations. That is an amendment of a trial of the appellate of what Mr. Lowe had submitted. I never spoke to Mr. Lowe about any of these grounds that he submitted. Even though there was some good grounds, he left out the most important one, which is ineffective assistance of counsel.
Right, sir,
after counsel filed ineffective assistance on himself.
Right, this is actually the Court of Appeals opinion, sir. So your objection is noted for the record, but it's overruled and submitted.
Okay.
All right, Mr. Peters.
Okay, and then R2, respondent would like to tender into evidence the appellant brief in Mr. Worthy's appeal. And I'll scroll down so y'all can see.
All right, any objection, Mr. Worthy?
No, sir.
All right, submitted.
Okay, and at this time, respondent would like to tender R3, which is the appellee brief in Mr. Worthy's appeal. And I'll scroll down. Yeah.
All right, any objection, Mr. Worthy?
No, sir.
All right, it's submitted.
Okay. And then R4 is the clerk's record and the underlying proceedings in Mr. Worthy's case. This is quite a lengthy, well, not too lengthy.
Right, can you see that, Mr. Worthy?
Yes, sir.
All right. Any objection to this exhibit?
No, sir.
Submitted.
Okay, and then R5 is the trial transcript from Mr. Worthy's proceedings.
Right, and that appears to be about 200 or 300 or 225 pages. So, Mr.
Yes.
Worthy, any objection to the court having access to your trial transcript?
No, sir.
Submitted.
Okay, and then R6 is the sentencing transcript from his underlying proceedings.
Right, any objection?
No, sir.
Right, submitted.
And finally, R7 is the motion for new trial hearing transcript.
All right, any objection to 7?
No, sir.
All right, 7 is admitted.
And those are all the exhibits we have today, Your Honor.
All right, thank you, Mr. Peters. And Mr. Worthy,
Yes, sir.
my court report is all of your testimony, everything that's been said throughout this hearing. So I'll have a transcript, a record of everything that you have said. Do you wish to testify further at this time?
Yes, sir.
All right, raise your right hand and be sworn.
Sir?
Was he sworn in earlier? No, sir. I didn't think so. All right, sir, if you would raise your right hand and be sworn.
Do you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
All right, thank you, sir. All right, Mr. Worthy, you may testify.
Okay, thank you. Your Honor, on the void and invalid indictment, when I spoke to my trial attorney for the first time, it was on July the 5th, and about my case. I went to jury trial July the 9th. So there was really no way for him to prepare adequate defense for me. I discussed a lot of things with him, and the main thing was I was working at Advanced Steel, which sandblasting, which is why I had scalps on my knuckles and not consistent with me being in a fight that never came out. When I got locked up, the property that Firewalker Drive was a property that I owned, that I lived at. But my sister and her husband saved my property at my home, and because of that, I felt some type of way, like I owed them. So I would go there during the day and stay there, but leave at night to a room. You know, when I filed a lack of probable cause, it was because they never had the warrant. Do you have a copy of the warrant, Mr. Peters?
Everything should be included in the clerk's record, which I think was R2. Yes, or R4.
I actually sent a copy with my brief that I mailed in. I sent a copy of the warrant with the brief, the only copy I had with the brief that I submitted. In that brief, you would see that, in that warrant, you would see that the detectives left out the name of the unanimous caller, which disallowed the magistrate judge to make an independent investigation or determination of whether or not that what they was getting was accurate or truthful. Because if he did an independent investigation, he'd have found out it was based on untruthful statements. And I don't think that that's how you get probable cause. I think that I am supposed to be secure in my home of the legal search and seizure and the issuance of a warrant without probable cause that led to a void and invalid indictment where the crime happened on the 21st and the indictment said it happened on the 24th. When I told my trial counsel, he said it means nothing. I asked him about the multi-counts on the indictment, 3 counts of aggravated assault on one person, and all of them have the same code, but yet different elements in each indictment should be proven. When the Georgia appeal broke it down, they changed the codes and correct them. 16-5-20A1, and not all of them having the same codes. But yet they vacated on the amended motion some of the mergers and still merged them together after they vacated. Doesn't vacate mean they do away with it? But a motion to suppress the evidence, a bloody Captain America t-shirt and Adidas tennis shoes, which did not contain the blood of the victim nor my DNA. I live in one place, but they went and found this shirt in another place, somewhere I do not live, in that person's trash, and tried to tie it to me. Yeah, that's not how law is supposed to work. No one asked me, was I at this house? Is this the address? None of that. I just went and got it, went and did it. Wherever they was getting their information from, it was wrong. I was going to school, get my master's degree, and working. No one cared about that. My lawyer never brought that out. Of course, he was on to my lawyer 4 days before I went to jury trial. Doesn't have to do a notice of intent, like when you get appointed to a person, they changed my lawyer 3 times while I was in prison. Merely having counsel is not adequate enough. Me having counsel that, well, they can reach out to me, especially during the phase of a jury trial, is very important. I never spoke to now lawyer, but Mr. Lee Henley, who retired, who went to the probation revocation hearing with me when the victim, who said, yeah, that was me in open court, said in probation revocation hearing. I never said Mr. Worthy did it. Why? Because I do not fit the description. There's another exhibit. Her statement of the description that she gave when her mind was fresh when the robbery first happened. And not when they told her I did it. And she started going with that. That's really all I have.
All right, anything else? Mr. Peters?
No, Your Honor.
Any cross-examination?
No, Your Honor.
All right. Here's, that you wish to tender, Mr. Ward? Mr. Worthy, do you have any exhibits that you wish to tender?
Yes, sir, I have some exhibit, and I also have a brief, the original brief that I mailed in. If they don't have a copy that I'd like to submit to as well.
All right, I was looking through the record, and I do see that there is a brief pro se habeas corpus petition brief and argument. Is that the brief you're referring to?
Yes, sir.
Okay, all right, that's dated. Well, it looks like it was stamped into the clerk's office January 27th of this year. So, do you wish to submit an additional brief, or are you?
No, that's the same brief, sir.
Okay, all right. Mr. Peters, does the respondent wish to submit a brief at the conclusion of after the transcript's available?
Yes, Your Honor.
Okay, all right. How much time do you need after receipt of transcript?
It's up to you, but 30 days works for us.
Okay, 30 days to receive the transcript. All right, Mr. Worthy, I'm going to consider the record, your argument, all of the exhibits, and I'll get an order out to you. All right?
Yes, sir.
That concludes the hearing. Thank you, sir.
Excuse me, sir.
Yes, sir.
How do I submit my exhibits? All of my exhibits should be a part of my record, like the DNA crime report.
Let's do this. It's very likely that any of the exhibits that you want to tender are included in what the respondent, since they've submitted the entire record. So why don't you go through them individually at this time, and let's make sure we have them. If we don't, I'll leave the record open, and I'll allow the staff there at Smith to send those documents into the clerk's office to make sure that they're included. I'm gonna make sure you have an opportunity to submit your exhibits, sir. But let's
Yes, sir.
let's go through each one, and Mr. Peters, if you'll consider them and make sure that we have a copy. If we already have a copy, there's no sense in having two copies of the same thing. But if there's anything that's not already in the record, Mr. Worthy, we'll make sure you have the opportunity to tender that, okay?
All right. Yes, sir.
What's your first exhibit?
A DNA crime report, the DNA crime report.
Mr. Peters, is that in the record?
Give me 1 second, Your Honor, please.
I realize I'm kind of putting you under the gun here, but
It's okay.
it was easy, everybody, as I say.
Very true. I do not see it in the index. Yeah, I don't see it in the index.
Any objection to petitioner's exhibit 1, the DNA crime lab report?
I would like to see it. I know it's kind of difficult to share documents, but yeah, I would like to see it.
The court's going to admit it. That way you'll get a chance to see it. All right, what's your next exhibit?
The Rome Police Department report on April the 21st by Officer Stephen Smith and Officer Chris D. Hart, the first arriving officers, I think, at the scene that actually talked to the victim, who she gave a statement of the identity of the person who actually committed the crime.
Mr. Peters, any objection? And Mr. Worthy, you understand this isn't an opportunity to retry your case. I'm just considering the constitutional issues that are raised in the petition.
Right. Let's see. Also, you already have a copy of the indictment.
Yes, sir.
Yes.
And having a copy of the indictment, it's not an error for my lawyer who never objected to the indictment, because had he did on this multi-count indictment, I don't think we would be here today. But on these aggravated assault, all of them have the same code, the code section for aggravated assault, with different elements read in them.
Okay, I understand that, but I don't think it's necessary to enter that as an exhibit this time because we already have it. So,
well, that's all the exhibits that I like to submit.
Exhibit 1 and Exhibit 2. Now, the second exhibit, I just want to make sure we're clear. The report from the police department.
Right.
Any objection, Mr. Peters, to?
No, Your Honor.
All right. So, is there someone there with you, Mr. Worthy, from the staff there at Smith?
Yes, I'm here.
All right, ma'am, could you assist us in ensuring that these two exhibits identified by Mr. Worthy make it to the?
Yes, sir.
All right, thank you, sir. Thank you. All right, that concludes the hearing. I'll get an order out to you, Mr. Worthy. Thank you, sir.
Thank you.
Thank you, Mr. Locke.
All right, Mr. Peters, what's the next case we're gonna take up?
I believe it's Baruch Benjamin.
All right, has Mr. Benjamin made it up? I know he was on his way up earlier.
Ron, I was just added as a participant. I would be the attorney for Mr. Benjamin. I was looking to see about Mr. Lawrence Daniel to see if he was an attendee or a participant. He would be the appellate attorney on the case that we would be calling as a witness, or the Attorney General would be calling.
Who's there, Judge?
Yes, it appears that Mr. Daniel is here. There's someone with the initials LWDAN. And I believe that's the individual that you are referring to. All right.
There we
Is
go. I'm
Mr.
sorry. I'm here. Good morning, Your Honor.
All right. So Mr. Daniels here. Mr. Is it Benyamin?
Yes, sir.
All right. Am I pronouncing your name correctly, Mr. Benyamin?
Yes, sir.
All right, good. Court calls the case of Baruch Benyamin versus Brian Adams, case number 2019 HC 76. And petitioner is represented by Vernon Smith. Mr. Smith, good morning.
Good morning, Your Honor.
Are you ready to proceed?
Yes, Your Honor.
All right, you may do so.
Your Honor, we will be proceeding on the amendment to the writ of habeas that was filed on May the 12th. I've submitted a copy of that to the Attorney General. I believe they're aware of that. That will be our sole enumeration. We would, based on that, which is ground of the appellate attorney being ineffective by not arguing inadmissible 404B evidence that was admitted for trial after a hearing and prior to the trial by the trial judge. And we would be calling Mr. Lawrence Daniel to the stand.
All right, Mr. Daniel, good morning.
Good morning, Your Honor.
If you would raise your right hand and sworn, please, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Lawrence Daniel, Lawrence, Daniel, Daniel.
Morning, Mr. Daniel.
Good morning.
You can hear me fine?
Yes, sir.
Let me know if something comes up, because with these technical things, sometimes my audio has been going in and out a little bit this morning. But you were familiar with Baruch Benyamin?
Yes, sir.
And was it because you wrote the appeal for his case?
Correct.
15, is that right?
Yes.
And this was a case that involved armed robbery, aggravated assault, possession of a firearm by convicted felon, and possession of a firearm by commission of crime?
Correct.
In 2015, Mr. Daniel, what would you say your percentage of practice was devoted to criminal defense?
About 2/3.
And at that period of time, approximately how many appeals would you say you had done?
Let's see, we were approaching the 100 mark.
Okay. This particular, you had 2 grounds that you raised?
Yes.
And I'm saying this, I believe you are kind of familiar, you familiarized yourself with the appeal that you wrote, and you kind of looked over some of the transcripts before this hearing?
I've looked back at it, yes.
Okay. And the first ground that you put was insufficient evidence to convict, the second being ineffective assistance of counsel.
Correct.
Under the ineffective assistance of counsel, you listed several reasons why counsel was ineffective.
Yes.
You did not, however, in your appeal, have it grounds that the 404B evidence that was admitted by the trial judge should not have been admitted.
Correct.
And it was not a strategy on your part?
It was an error on my part. It was oddly, my recollection at this point is it was the very next appeal that I dealt with where I belatedly figured out that any pretrial motions that get a written ruling on, that those issues are preserved whether they're objected to at trial or not. So
in this particular case, there was a ruling prior to trial.
Yes.
And had you seen that ruling or known about that, you would have argued the 404B motion, or 404B should have been admitted.
I should not have been admitted. Yes, sir.
Right. Absolutely. So it was essentially you were not doing that because you didn't think it had merit.
I incorrectly thought it had been waived. And having looked at the proffer by the state in the pretrial motion, it was kind of a minimalistic proffer, in my opinion.
All right, thank you. That's all the questions that I have for you.
Cross-examination, Mr. Peters.
Yes, Mr. Daniel. First, just to get some background information, hopefully I don't overlap too much with direct, but how are you currently employed?
I'm self-employed. I'm doing about still 2/3 criminal and 1/3 juvenile.
Okay. What year were you admitted to the Georgia bar?
1986.
And since becoming a member, have you been employed in that time?
Let's see, did a little civil work, then I was a prosecutor for 5 years, and then my boss lost the election. I've been self-employed since.
Okay. Approximately how many felony trials had you handled at the time of your representation?
In 2015,
Yes, sir. Just ballpark.
40
Okay. And were you appointed or retained?
appointed.
Okay. At which point in the proceedings were you appointed?
Post-conviction, I don't know if I filed the motion for new trial or not, but Douglas County does a pretty good job of somebody from their office, from the public defender's office, has somebody in the courtroom when sentencing goes down, and they're pretty quick about finding somebody off their appellate list to call and try to appoint.
Okay. So did you file a skeletal motion for new trial or just an amended one?
I don't recall. My standard procedure would be to find a skeletal one, and then I file a pretty extensive amended motion for new trial.
So did you have good contact with the trial attorney at that time to kind of prepare?
Don't recall at this point. Let's see, who was it? Second. Can you refresh my recollection who trial counsel was?
I'll withdraw the question. Did you have contact with petitioner at that time in preparation?
Yeah, that would tend to be by mail. Although we're getting the Zoom is such a improvement, but yeah, my routine is to send copies of all transcripts that come into my possession, drafts of briefs, and I always include self-addressed stamped envelopes so that they can respond.
Okay. Did petitioner ever tell you specific issues that he thought you should raise on appeal?
I don't remember at this point.
Okay.
What I recollect about Mr. Baruch is, and it's been some years, was that I don't know how well educated he is, but I think that might have been a factor, but I don't recollect getting a lot of specific instructions from him.
Okay. So at the time, did you feel that you raised the most meritorious issues?
I did with, as I told Mr. Smith, and I thought that trial counsel had waived the 404B issue, but now I don't think he did. So I could have raised it as a separate issue.
Okay, but at the time, you believe that you raised the most meritorious issues.
Yeah.
It's just looking back now, you're saying I should have done something different.
Correct, because misinterpretation of the code on my part.
Okay. So you thought the 404B issue was waived? Can you explain why?
Well, I thought that it had been raised during trial and then not objected to when the submission of that was made to the jury. But if it's done as a pretrial motion with a written order, then it should be admissible, whether there's a subsequent objection or not.
Okay.
If I'm correct.
So, okay. Why do you think the trial court erred in admitting the 404B evidence?
Well, the best that was presented in the proffer was that, there's 3 co-defendants, they're living together in this apartment, they find a gun that could vary from a subsequent burglary that very well could have been owned by someone else. And that's what they had. They did not have enough, I think, to sink a separate indictment. I don't think they did.
No further questions, Your Honor.
Question to read a record, Smith?
No, Your Honor.
All right, any other witnesses, Mr. Smith?
I don't, Your Honor. It's my understanding in communicating with the Attorney General's office that they do have a number of exhibits that they plan on tendering. If they don't, then I would have tendered the transcripts of the case and that sort of thing, but I do believe they have those that they're going to tender.
All right, Mr. Peters, do you have the exhibits?
Yes, Your Honor. Let me share my screen.
Okay, what we'll do, Mr. Smith, is I'm going to let Mr. Peters go through these exhibits. If there's anything that you would like to tender to supplement that record, if you'll make me aware of that, we'll take that up as well. But if you
Thank you, Your Honor. And just for the record, I have no further need for Mr. Daniel if I know he has some conflicts in other areas.
Mr. Daniel, you're welcome to stay with us, but you're free to leave.
Thank you, Your Honor. I'd love to. I am going to ask, if I may, Mr. Smith, keep me posted on what happened. Your Honor, I would request to be excused. They're holding for me in a different venue.
All right. You're free to go. Thank you, sir.
Thank you, Your Honor.
All right, so Mr. Peters, you want to go through the respondents' exhibits?
Yes, Your Honor. Can you all see my screen?
We can.
Yes.
Okay. So respondents 1 is the jury trial hearing transcripts from February 25th to 28th. And it's kind of piecemealed into 3 parts, and I'll scroll around. So this time we'd like to tender R1.
Any objection, Mr. Smith?
No objection, Your Honor. And I assume that all 3 parts are on that on what are being tendered.
All right. R1's admitted.
Okay. Then turning to R2 is the sentencing hearing transcript on March 13th, 2013.
Any objection to R2?
No objection.
All right, R2 is admitted.
Okay, and now R3 is the amended motion for new trial hearing transcript, which took place on April 15th, 2015.
No objection.
All right, submitted.
And then these next 4 tabs are R4, which are the record. 1, 2, 3, and 4.
No objection.
All right, they're admitted.
Okay, and R5 is the appellant's brief.
And no objection to that as well.
R5's admitted.
R6 is the appellee's brief.
No objection.
Submitted.
And then R7 is the unpublished Court of Appeals opinion.
No objection.
All right, submitted.
And those are all the exhibits we have, Your Honor.
All right, Mr. Smith, you have additional exhibits?
We do not have any exhibits, Your Honor.
Okay. All right. Anything else we need to take up?
No, Your Honor. Would ask for 30 days to file a brief after the transcripts are done. I don't believe that should take long, although I know there's probably a backlog of transcript orders. I would ask that I have if I could get a copy or at least the number or contact information for the court reporter. And I can do that on chat if you guys would rather.
She says she would rather.
Okay, absolutely. Can I get her name so I can just send her to the chat? Or?
Sandy Simmons. Sandy Simmons.
Okay. And I don't obviously I don't see her on here. If she wouldn't mind just sending that to my chat number, I'll stay on here until it gets through.
Okay.
I can email it to you.
Yeah.
I think I have an email.
That'll work as well.
They'll email the information to your email account.
Fantastic. Thank you very much.
Thank you. All right, and 30 days to file a brief after receipt of transcript. Same, Mr. Peters?
30 days to respond, Your Honor. That works for us. That works for us.
Okay. All right, that concludes the hearing.
Thank you, Your Honor. My big excuse.
You may. All right, Mr. Benjamin, that concludes the hearing. I'm sure your attorney will be in touch with you, okay? All right, thank you, sir. What do we have next?
Eric, you want to do the Cruz case and then that would free up the folks at GSP?
Yes, that works for me.
If that's amenable to your honor.
Absolutely.
Your Honor, this is Miss State Prison. I have a question for you.
Okay.
Do you guys have Demario Goodrum on your docket for today?
We did. Let's see.
That one's continued, Judge.
Yeah, that case continued off of this calendar. I think that was due to a conflict, with petitioner's counsel. So we're not going forward on.
So he's not needed, right?
That's right.
Okay, and after GSP, who would you like to have next?
Ms. Smith and Ms. Edwards, I'll let you make that call.
We could do Mr. Weldon.
Okay, thank you.
Before we do Mr. Weldon, we're gonna finish with GSP, is that correct?
Yes, Your Honor. Mr. Cruz is the only inmate at GSP, and once we get his case done, that would finish them up.
Jack Cruz. Are you Mr. Cruz?
Yes, sir.
Can you hear me?
Yes, sir. Fine.
All right. Good morning.
Good morning, sir.
Let's see. All right, court calls case number 2020 HC 52 JS, which is styled as Jack Cruz versus Provenza Bobbitt as the warden. As the respondent. And Mr. Cruz is here, sir. Are you ready to proceed with this hearing?
I am, sir.
All right. And Ms. Peters, is this your case, or?
Yes, Your Honor.
Okay, are you ready to proceed on behalf of the respondent?
Yes, Your Honor.
All right, you would give me a brief outline of the allegations contained in the petition?
Yes, Your Honor. Petitioner Cruz is challenging his May 2017 Dougherty County conviction for burglary, which was affirmed on appeal in Cruz v. State, number A20A0920, Georgia Court of Appeals. That's a 2020 case and it's unpublished. In his petition, petitioner has raised 4 grounds. Ground 1, petitioner alleges that he received ineffective assistance of counsel when trial counsel failed to conduct pretrial investigations and witness interviews. Ground 2, petitioner alleges that the trial court erred in allowing a, quote, 3-page recidivist indictment to go back with the jury during deliberations in the guilt-innocence part of trial, end quote. Ground 3, petitioner alleges that the trial court erred in admitting, over petitioner's objection, a 911 tape of a witness and further allowing that tape to be played for the jury multiple times. And finally, ground 4, petitioner alleges that the trial court erred in admitting, over petitioner's objection, 2 agricultural instruments during trial. And those are the 4 grounds.
Mr. Cruz, do you have any witnesses that you wish to call?
No, sir.
Mr. Peters, do you have any witnesses?
No, Your Honor.
All right, just exhibits.
Just exhibits.
All right, do you want to tender those at this time?
Yes, Your Honor.
All right. Now, Mr. Cruz, just so you'll understand what we're doing here, you have raised certain allegations in your petition that contesting or alleging that there were violations of your constitutional rights, which ultimately resulted in your current incarceration. Court needs the benefit of the record. getting a lot of noise from some. Okay, that's better. Anyway, the reason these exhibits are being tendered, sir, is so that I can go back and look at the history of your case, the procedural history of your case, and see the documents.
I'm losing you, sir.
Did you hear anything I just said, Mr. Cruz?
No, sir.
Okay.
I mean, just skipping.
All right, can you hear me better now?
Yes, sir.
I think we're having a lot of interference from some of the noise that was coming in from one of the facilities there, so that seems to have been addressed, so maybe it's going to go better now. But what I was explaining to you is that you have made certain allegations in your petition that contest the constitutionality of you being incarcerated at this point. And in order to determine whether there's any merit to your claims, the court needs the benefit of the record of your case. So these documents that the respondent is about to tender as exhibits constitute the record of your case. So I was just explaining that that's what these records are.
I didn't get that last part.
I was explaining to you that that's what these records are for. So I'll have access to the procedural history of your case. All right?
Yes,
sir.
Okay, can everybody see my shared screen?
Yes.
Okay. R1 is the clerk's record from the underlying proceedings, and I'll scroll down a little bit.
All right, Mr. Cruz, any objection to R1 being admitted?
no, sir.
All right, it's admitted without objection.
Okay. R2 is the jury trial transcript, which was held on May 5th through 6th, 2017. Scroll down.
All right, any objection to Mr. Cruz?
No, sir, that's fine.
All right, it's admitted.
Okay, and at this time, we'd like to tender R3, which is the motion for new trial hearing transcript held on April 16th, 2018. And I'll scroll down with that as well.
Any objection, Mr. Cruz?
No, sir.
All right, it's admitted.
Okay, at this time, we'd like to tender R4, which is the appellant's brief in Cruz v. State, number 820A0920. And I'll scroll down.
Any objection?
And that's the end of it.
Submitted.
Okay, at this time, we'd like to tender R5, which is the appellee's brief and his appeal.
Any objection, Mr. Cruz?
No, sir.
All right, file submitted.
And lastly is R6, which is the unpublished Court of Appeals opinion and his appeal.
All right, any objection to the Court of Appeals opinion, Mr.
No,
Cruz?
sir.
All right, so it's submitted.
And those are all the exhibits we have today, Your Honor.
All right. So, Mr. Cruz, is there anything you want to tell me? Do you have any exhibits that you wish to tender into evidence that haven't already been admitted?
No, sir, I don't think I do. The only thing that I do have is I've been trying to contact my appeal attorney, Mr. Lewis. I've written him 3 letters from the addresses that he gave me. One of them was from the appeals court answer to my appeal, and has it been sent back, returned to sender? He has information that I wanted to put forth as to why issues wasn't brought up at the Court of Appeals that were brought up in the motion for new trial that Attorney Monroe represented me on. one, the major issues was, ineffective assistance of counsel, and, well, that was the main thing. And,
Ineffective,
and the indictment issue, yes, sir.
ineffective assistance of trial counsel.
Yes, sir.
Okay. All right, what I intend to do, sir, is give you the opportunity to submit a brief if you would like to, which would afford you more time to contact the individual that you've identified. My court reporter is going to prepare a transcript of this hearing, and you would have the benefit of that transcript in addition to having time to contact this individual. Then you could submit in writing any argument that you would like to make.
All right, sir.
All right. Mr. Peters, would the respondent as well like to submit a brief or stand on the
Yes.
record? Or, okay.
Yes, Your Honor.
30 days from receipt of transcript. All right. Thank you, Mr. Peters. Good luck to you. I'll get an order out to you after I receive the briefs.
All right, sir.
Thank you, sir. All right, looks like we've got 3 left. And Ms. Smith, I'm going to let you, Mr. Peters, since you're more familiar with the cases and the nature of the claims and whatnot, we'll proceed as you tell me.
Thank you, Your Honor. I think we said we'd take the Weldon case next, and I'm actually handling that, but I'm going to ask for Mr. Peters' assistance if we do go forward in tendering the documents. I just slid the list under his door. It's sitting at, he's doing such a masterful job, and that's still one of my IT challenges.
He always does. That's all right, so are you Mr. Weldon there at Smith State Prison?
Yes, sir.
All right. Good morning, sir. How are you?
I'm good. How you doing?
I'm good. All right. Court calls the case of Brian Weldon versus Terrence Kilpatrick, case number 2019 HC 46. And Mr. Weldon, are you ready to proceed to the hearing?
No, sir, because the last time we had court, I want to say in March, I was telling you that I'm currently incarcerated on 2 cases, and my other case is the first case that I was convicted on, and this case was convicted a year later, but it's like they coincide with each other. It's out of 2 different counties, but it's the same charges. Like basically, it was a robbery spree. They were saying it was a robbing spree amongst 2 different counties. So I haven't. That case has been scheduled. It was scheduled July 21st, but they rescheduled because it's a trial or something to August 11th. So I won't be finished with that one until at least August 11th. So I can't like properly defend this case without going forth with that case first. I put in the continuance maybe a week and a half ago, 2 weeks ago at the most. I don't know if y'all received it or not. I didn't get a response back from the court saying that they granted the continuance or not. So I don't know.
I don't see a motion for continuance. Ms. Smith, your response to the motion?
Under the circumstances, Judge, we continued it from last time because he said he wasn't ready, but you did hear the testimony of his appellate attorney. And so this was reset for today to let Mr. Weldon put up his side of the case. I'm somewhat familiar with this other case, and I think we've gone forward in that case and tried to close the record. I could be confusing it. But at any rate, since we don't have a witness here and this is his show, we don't oppose his request for a continuance.
All right, Mr. Weldon, so we'll continue this to another calendar and proceed at that time.
Okay.
All right.
So can I ask you, like, okay, once, like I said, I go to court on my other case August 11th. Once I'm finished that, is it any way that way, just in case, like say for instance, the state continues it the next time when I go in August, or they give me another date because they have another trial or whatever the case may be, instead of us having to come back here and me continue it because I haven't finished this case, is there any way that I can write and make sure that, you know what I'm saying? Like we want to, cause this is, I know y'all have a full schedule, you know, so I don't know if I need to write, cause like I said, I wrote and I didn't get a response. Like I don't know what the mail is at the prison, but we having an issue with that down here as well.
Mr. Weldon, I appreciate your concern for my schedule and everybody else's schedule, but what I'm gonna do is continue this to my next habeas calendar, and we'll just reconsider at that time. As Ms. Smith indicated, we've already obtained the testimony of the appellate counsel. So all that's left is for you to put up your side of the case. So I'm gonna keep it on track, and first available opportunity, we're gonna conclude the hearing, okay?
Okay.
All right, thank you, sir. Have a good day.
All right, thank you.
All right, so we're down to Rollison and Leonard.
Yes, your judge, and the Rollison case we were trying to hold because the witness had a conflict, and so if we could do the Brandon Leonard case, and Mr. Peters is going to handle that.
All right, are you Brandon Leonard?
Yes, sir.
Good morning, how are you, sir?
All right, how about yourself?
Good. This is case number 2028C27, styled as Brandon Leonard versus Brian Adams. Are you ready to proceed, Mr. Leonard?
Yes, sir, I am.
And Mr. Peters is here on behalf of the respondent. Are you ready as well?
Yes.
All right, Mr. Peters, if you could give a brief outline of the allegations contained in the petition.
Yes, Your Honor. Mr. Leonard is challenging his 2008 Fulton County jury trial convictions for 2 counts of malice murder and 2 counts of possession of a firearm during the commission of a felony. These convictions were affirmed on appeal in Leonard v. State, 292 Georgia 214, and that's a 2012 case. In his habeas petition, he has raised 3 grounds. In ground 1, he alleges his 5th and 14th Amendment rights under the Georgia Constitution were violated when he was forced to defend against the felony charges by the Superior Court of Fulton County without said court legally establishing subject matter jurisdiction because there were no records of the grand jury proceedings in the clerk's office to verify that the indictment was returned as a true bill into open court. That's ground 1. Ground 2, petitioner alleges that his 5th and 14th Amendment rights under the Georgia Constitution were violated when the Superior Court of Fulton County convicted petitioner without first establishing legal subject matter jurisdiction because there were no records in the clerk's office to verify that the indictment was ever returned into open court as a true bill. And then finally, ground 3, petitioner alleges he received ineffective assistance of trial and appellate counsel for failing to investigate and/or challenge the validity of this illegal indictment in his complaint, and also by failing to investigate the facts of the case in good faith and loyalty to petitioner. And those are the 3 grounds, Your Honor.
All right, Mr. Leonard, do you have any witnesses that you intend to call?
I thought I might have to get a continuance because I did not subpoena my trial attorney. But I had no knowledge of me ever having to do that because this is my first time going through this process, and I haven't been able to get to the law library because we barely get any access to the law library.
All right, Mr. Peters, your response to the motion for continuance.
Just so the court is aware, we had the first setting of this case on January 27th, 2021. At that hearing, appellate counsel Barbara Collins testified. So we received her testimony and then we continued it in order for petitioner to have time to receive more documents. Our position on these grounds is that they're procedurally defaulted. We don't object to the continuance, but it's in your discretion, Your Honor.
All right, well, it's already been set one time, and we don't want to build a backlog, obviously. We're going to go forward today. The motion for continuance is denied. What I'm going to do is ask Mr. But do you have any witnesses, Mr. Peters?
No, Your Honor.
At this point? All right, so, Mr. Leonard, anything you want to tell me? Any exhibits that you wish to tender?
Yes, sir, I do.
All right, you have exhibits. Before we get to that, I'm going to allow the Mr. Peters, counsel for the respondent, to submit any exhibits he has, and it may be that those exhibits will encompass, Mr. Leonard, what you intend to enter into the record as well. So, Mr. Peters, if you would submit your exhibit.
Yes, Your Honor. Okay. So respondent, at this time, respondent tenders R1, which is the record in the underlying criminal case. We've separated this out into, it's very large, so we've separated out into about 7 segments, and I'll go through those now. There's 1, 2, 3, 4, 5, 6, and 7.
All right, any objection? Mr. Leonard, do you have any objection to respondent exhibits 1 through 7?
No, sir. No, sir.
All right, they're admitted without objection.
Okay, and then R2 is the volume 1 of the trial transcript, and here it is, and I'll scroll down for you all. Now, this time, respondent would tender R2.
Any objection?
No, sir.
All right, it's admitted.
At this time, respondent would tender R3, which is volume 2 of the trial transcript.
Okay, any objection?
No, sir.
All right, it's admitted.
Volume 4, or R4, is volume 3 of the trial transcript.
All right, any objection?
No, sir.
R5 is volume 4 of the trial transcript.
Any objection to R5?
No, sir.
All right, it's admitted.
R6 is the transcript of a motions hearing held on December 17th, 2007.
Any objection to R6?
No, sir.
All right.
R7 is the appellant's brief.
All right. Any objection to R7, Mr. Leonard?
No, sir.
All right, it's admitted.
R8 is the appellee's brief.
All right, any objection to R8?
No, sir.
It's admitted.
R9 is the appellee's brief of the DA. R8 was the AG's brief. R9 is the DA's brief.
All right. It looks like it said 10.
Oh.
Put that sticker. Yeah.
Yeah, I believe it was mislabeled. Oh, I'm sorry. Oh, that's the motions hearing. I'm sorry. There's a lot of exhibits and it kind of got misordered. Give me 1 second. Here's the DA appellee brief. That's R9.
All right. Any objection to R9?
No, sir.
All right, it's admitted.
And then Lastly, R10 is the motion for new trial hearing transcript, which was held on July 14th, 2010. And that's R10.
Any objection to R10?
No, sir.
All right, it's admitted.
Okay, and that's all of the exhibits respondent intends to introduce.
All right. So, Mr. Leonard, do you wish to testify?
I couldn't hear you,
Do you wish to testify at this time?
Well, I mean, yes, I do. I do.
All right. Raise your right hand and be sworn, please.
Do you swear to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, and before we get started, Mr. Leonard, I want to make sure we're clear. This is a hearing on the petition that you filed seeking habeas relief. This is not an opportunity to go back and retry your case. This is an opportunity for you to address the constitutional challenges that you set out in your petition. So I'm going to limit your testimony to that relevant testimony concerning this action, okay?
Yes, sir.
All right, you may proceed.
Okay. Good morning, y'all. I'm here for this honorable court today to plead my case on the issue of lack of jurisdiction of the subject matter, which was never established legally by the Superior Court of Fulton County, Georgia. A non-amendable defect which appears on the face of the records of this case, and also fraud and prejudice committed by other Fulton County Superior Court officials in an illegal judicial proceeding which resulted in my current conviction and sentence. According to authority rulings and various citations of law, it is manifestly understood that the grand jury or the sworn bailiff of the grand jury must return into open court a true bill of indictment, and the same must be entered upon the minutes of the proceedings of that court by its clerk before a court can obtain jurisdiction of a case. And until it is so presented, it is no indictment, and any and all judgments rendered by that court are absolutely void for lack of jurisdiction of the subject matter. Your Honor, I have documented record evidence of the fact that the Superior Court of Fulton County does not possess the records of those proceedings and that they do not exist in the file of this case. Therefore, there could have been no legal presentment and or return of indictment number 07 SC 61277 into open court to prove that it was duly sanctioned for the trial court to try the case, which renders all the proceedings that led to this current conviction and sentence altogether void. Ineffective assistance of counsel stems from my trial and appellate counsel failing to investigate the validity of the illegally endorsed and filed indictment, and also to investigate the facts of this case in good faith in the lawyers. Sufficient record proof of the return of the indictment is the evidence required by law to establish the identity of indictments, so as to protect citizens from having to defend against charges never acted upon or presented by the grand jury. From my research and understanding of the law, Your Honor, this conviction was clearly obtained in violation of my 5th, 6th, and 14th Amendment rights, guaranteed by the United States Constitution and Article 1, Section 1, Paragraph 1 of the Georgia Constitution. Wherefore, I respectfully and humbly pray that this honorable court, after considering the indispensable evidence provided and the facts of law and procedure into the appropriate findings of fact and conclusions of law, and grant this petition for habeas corpus relief.
All right. Thank you, Mr. Leonard. Do you have any exhibits that have not already been tendered in the record? And the only reason I say that, there's no sense in having two copies of the same document from both sides, but are there any documents that you wish to tender into the record at this time?
All the documents that I have already been submitted, but I have those documents right here, again, to tender into evidence.
Okay. Well, like I said, there's no sense in having two copies of the same thing. So the court reporter is going to prepare a transcript of this hearing, and I'll give you the opportunity to submit a brief after you've had the opportunity to go over the transcript. So you can have 30 days from receipt of transcript, same Mr. Peters, 30 days from receipt of transcript to submit the brief. All right? And after that, I'll get an order out to you. That concludes the hearing. Good luck to you, Mr. Leonard.
All right, thanks, sir.
Yes, sir. All right, and the Rollison case. Are you Mr. Rollison?
Yes, sir.
All right, good morning. How are you?
I'm well. How are you?
I'm good. This is case number 2018 HC 66, which is styled as Robert Kane Rollison versus Terrence Kilpatrick. The respondent. Are you ready to proceed, Mr. Rollison?
Yeah. Yes, sir.
And Ms. Smith, you're here for the respondent. Is that correct?
Yes, Your Honor, and we're ready to proceed. I see our witness, Mr. Groove, who was plea counsel, and I think Mr. Rawlison's father is a witness. I don't see the clerk of the Superior Court of Pulaski County, who I think was a third witness Mr. Rawlison wanted, but I have no information about that.
I was just looking at, are there anybody else logged in that's not reflected? Is the clerk from Pulaski County available? All right. So, Ms. Smith, if you would give a brief outline of the allegations contained in the petition.
Yes, Your Honor. Mr. Rawlison is challenging his Pulaski County murder conviction arising from a guilty plea entered in November 2014. It was malice murder. There was a second count of concealing the death, which was an all prost as part of the plea agreement. He has raised essentially 4 grounds. He's amended several times and recently filed a brief, and I think we've captured them all essentially. Basically, his first ground is a claim that the indictment was defective and void in that a Pulaski County elected official served as the grand jury foreperson. The indictment was not returned in open court. The count 1 did not allege an essential element of cause in order to establish a valid indictment, and the indictment did not allege a code section violation. Ground 2 is a contention that the court lacked subject matter jurisdiction and authority to enter judgment in his case because of this purportedly void indictment for the reasons I just outlined. Ground 3 is a claim that he received ineffective assistance of counsel because counsel did not challenge the validity and sufficiency of the indictment. And I think he's also alleged that counsel did not insist that a ruling be made on the general demurrers that counsel had filed, and did not ensure that the guilty plea was knowing and voluntary, and that he did not advise him that life without parole was a maximum sentence, not simply life, and tell him that the demurrers were outstanding. Ground 4 is a claim that the guilty plea was not knowingly, voluntarily, and intelligently entered, in that he was not told about the indictment issues and that the general demurrers were outstanding, and the court misstated the maximum sentence during the plea hearing. And ground 5 is a contention that the trial court erred in accepting the guilty plea when it knew, when it accepted it before factual basis was given, without an insufficient factual basis, and there was a pending order outstanding to assess his criminal responsibility. And if I may backtrack, I think there's the ineffective assistance claim in ground 3 was amended to allege that counsel should have also filed a special demurrer and a motion to quash and a motion, a plea and abatement.
What I intend, now, Mr. Rollison, it's my understanding that you have, is it 2 witnesses, John Rollison and Michael King, is that correct?
And Jeffrey Grube, Your Honor.
I'm sorry.
And also Jeffrey Grube.
All right, and I believe that the respondent's counsel intends to call Mr. Grube as a witness as well.
I didn't receive any notice of the respondent calling Mr. Grube as a witness, and also there's some issues with the wording of the grounds as they were amended. I didn't raise ineffectiveness on counsel's misinformation regarding the maximum possible sentence. I didn't raise that under the light of ineffectiveness of counsel. I have the motion that I amended the grounds with right here, and some of them, again, are worded differently.
Your response, Ms. Smith? If you'll unmute yourself, I've lost your audio.
Judge, if he's referring to the May 18, 2021 amendment, we stand on that, and I apologize if I misspoke. There have been several amendments, but is that May 18th pleading, Mr. Rollison, is that your statement of your
Yes, ma'am.
claims? Okay, thank you.
Yes, ma'am.
And it speaks for itself, Judge. You can see the ineffectiveness is not getting a ruling on general demurrers, not ensuring the plea was knowing and voluntary, not filing a special demurrer, not filing a motion to quash, and not filing a timely plea and abatement.
All right, what I intend to do is allow Ms. Smith to call witnesses and conduct direct examination. Mr. Rollison, I'll allow you to cross-examine her witnesses, and at the conclusion, I'll allow you to call your witnesses as well. All right?
Your Honor, before we go into the examination of witnesses, I'd like to check to see if the court has received some additional motions and exhibits that I filed on the 12th and the 18th. On May 13th, 2021, I mailed to the court and the Attorney General several documents, including the amended grounds, petitioner's intent to introduce several affidavits, also exhibit 0, 3, 4, 5, 6, 7, 8, and a motion to amend the previously submitted exhibit 202, and also a list of witnesses. And on the 18th, I submitted a motion for a supplemental brief, and also the supplemental brief. I would just like to verify that the court has those documents and the respondent got those.
We do, but we would insist that you tender those, Mr. Rollison. Simply mailing them in our position doesn't ensure that they are admitted into evidence, but we at least have it because we do have some objections to some of your documents.
All right, and I'll allow you to tender your exhibits at the conclusion of the testimony. All right, Ms. Smith, you may proceed.
Excuse me, Your Honor.
Yes, sir.
I submitted the Dukas Tecum subpoena, and I haven't had a chance to review the documents that Mr. Michael King produced. And there's some questions that I have for Mr. Grube about some of the documents contained in what was produced. Is there any chance that I could review the documents prior to me trying to admit them into evidence?
I'm not sure what you're asking me to do. If you're asking for a continuance, it's denied.
No, sir. I'm asking just to review some of the documents on the screen so I can understand what was produced by the Dukas Tecum and what wasn't, to basically ensure that the Dukas Tecum was complied with by Michael King.
Your response, Ms. Smith?
Your Honor, my understanding is he had asked for basically three things. One was a copy of the entire record in the criminal case. The second was a certified copy of the docket. And the third was all entries in the court's minute books on the June 24, 2013, which is the day the indictment was returned. if the clerk has submitted a complete copy of the record in the criminal case, it should be certified. It speaks for itself. We would not have any objection to that. The docket again would speak for itself. I know there's been some dispute about the entry of the minutes, as and I cannot speak to that, but they should be documents he's seen or should be familiar with, because he's had many opportunities up to now and has submitted things piecemeal to the court.
All right, we're gonna go forward at this time. Ms. Smith.
We would call Jeffrey Grube.
Mr. Grube, or Gruby rather.
I'm here, Your Honor.
All right. Good morning. How are you? I'm
fine. I appreciate the court's patience with me. I've been in House and Superior Court till about 20 minutes ago, and but I'm here. I don't see anybody, but I'm here.
And I can hear you, but I don't have a video. Can you click your video link on your computer? Maybe that. There you are.
Okay. Good morning.
Good morning. If you would raise your right hand and be sworn, please.
Do you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
All right, Ms. Smith, you may proceed.
Thank you, Your Honor. Please state your name and business address for the record.
My name is Jeffrey, Jeffrey. My middle name is Loyal, Loyal. Last name is Grube, Grube. I'm an attorney. I practice at 115 Carl Vinson Parkway, Warner Robins, Georgia, 31088.
I think Paul is muted.
Oh, sorry. Okay. How long have you been a member of the Georgia Bar, Mr. Grube?
Almost 42 years.
And if you could please describe for the court the nature of your practice after your admission to the bar up until the time you began representing Mr. Rollison.
Yes, I graduated from Mercer University in 1975 with a bachelor's degree, double major in history and political science. I went to the Walter F. George School of Law at Mercer University and graduated from there in 1979. My first year out of law school as I served as a law clerk for Judge C. Cloud Morgan, who was then the chief judge for the Macon Judicial Circuit. I did that for almost a year, and I've been in private practice in Warner Robins, Georgia, ever since then. And my office is at 115 Carl Vinson Parkway. I've been here now, gosh, almost 40 years. We built our building. I have mainly had a criminal trial practice through my entire career. I believe I was hired to represent young Mr. Rollison in 2013. Seems like it was the fall of 2013. But I was in private practice then. I had also, at that particular point in time, was serving as the attorney for the school board for Houston County, Georgia. I've been a municipal court judge now since 1982, so I was serving in that capacity, part-time capacity, for the city of Warner Robins and also the city of Centerville during that period of time. But up until the time that I was hired by Mr. Rollison's family, I was mainly a criminal defense lawyer with other areas of concentration, of general practice, domestic type work, but almost exclusively since 2013, I'm almost exclusively a criminal defense lawyer. I currently have a contract with Houston County, Georgia, over the last 4 or 5 years, where I do conflict public defender type cases that keeps me busy about 95% of the time.
Ms. Smith, you're apparently muted.
Okay, sorry, Judge.
All right.
So you were hired in the fall of 2013, did I understand you to say?
My recollection is, I do know that, throughout representing Mr. Rollison, I accumulated quite a bit of information that I put into a large banker's box that it's my recollection that I provided it to um, my client's mother 2 or 3 years ago. I looked for it yesterday, and my only recollection is that I provided everything that I had in his file to his mother.
Okay. And would this have been after the indictment was returned? Is that your recollection?
Yeah. I mean, after the case was completed.
I'm sorry, let me clarify that. When you entered the case, this would have been after Mr. Rollison had been indicted?
It was right when he was arrested.
Okay. And if the record showed that the indictment was returned in June 2013, would you have any reason to dispute that?
No, I don't have any reason to dispute that. Like I say, I got a call early on in the case from Clay Hall, who's a lawyer in Hawkinsville, who's friends with the family of my client, and they got me involved in the case pretty quick. You know, if the case go ahead.
I'm sorry, I didn't mean to interrupt you. If you want to finish your answer.
Well, I mean, if the case was indicted before, that wouldn't have been a problem for me because commonly when I get involved in a case, I file a standard group of motions and a lot more motions in a murder case. And I think there was some controversy at the very start of this case as to whether or not this is going to be charged in Bleckley County or in Pulaski County. That's why I say that whatever the record reflects as far as the dates of the grand jury meeting, I mean, I don't have any problem with that. Like I say, I have nothing to refer to because I don't have the file anymore.
Okay. So upon your entry into the case, what did you do in terms of investigation? And we realize you haven't had a chance to look at your file, but just if you could tell us today what you did.
Well, I didn't hire an investigator. I did the work myself. I spent a lot of time talking with the district attorney's office for that circuit. I talked to law enforcement about that case, and I spent a lot of time, of course, with my client and his family and others. But as far as, I didn't hire an investigator. I did that work myself.
Okay. And you indicated earlier you had filed some general motions. What would they have been?
Well, anytime I get any criminal case, I file there's a series of about 15 motions. If it's a murder case, I get much more specific as far as motions to suppress, if there's any photo ID lineup. Like I say, I'm satisfied with the motions that I filed for Mr. Rollison in this case. Throughout the prosecution of this case, the district attorney's office was very helpful in providing information for me. I would be amazed and surprised if they held anything back from me in this, but I was satisfied with the information that I was receiving in this case. The district attorney's office also provided me with numerous interviews with witnesses that I listened to every one of them more than once to try to get a good grip on what was going on with this case. But there was a lot of information provided to me by the district attorney's office concerning law enforcement's investigation of this case. The GBI was very involved in this case, and as the GBI is wont to do, the information that they provided to me in chronological order was very helpful for me in discussing the case with my client and also with my client's mother and my client's parents.
Okay. Did one of the motions you file include general demurs to the indictment?
I file one in every criminal case I get.
And do you recall if you got a ruling from the trial court on the general demur?
I don't know if there was a written order or not. I don't recall as us having hearings in the courtroom about it, but I'm certain I filed a general demur to it.
Okay.
At some point in time, I filed it, yes.
Okay. And would this have been sort of one of a standard sort of challenge, or did you specifically adjust it to the facts of this case?
I did not file a specific or a special demur to this case. I know I filed a general demur. You know, I file a general demur in every case, and you know, occasionally a superior court judge will grant a general demur. So, you know, a lot of people ask me why I keep filing them, and I'm always trying to find a way to help my client with motions. But I file a general demur in every case that I get.
Okay.
Once it's been indicted.
Okay. Do you recall whether or not it was brought to your attention by Mr. Rollison or someone else, or you discovered on your own the fact that the person who was the foreperson for the grand jury, Henry Cravey, may have been an elected official there in the city of Hawkinsville?
It seems like I heard something about that, but this would have, and like I say, my recollection is that this happened after, maybe after we pled the case. But I may be wrong. If it's something that I should have objected to, then you know, ma'am, I'm the kind of lawyer that I file a motion not to be litigious, but I file a motion if there's any way at all that it can help me. But no, I don't remember filing any sort of motion based on the fact that one of the grand jurors was an elected official. I do remember that coming up, but it was after the case had been completed. That's my recollection.
Okay. Did there come a time when you requested an evaluation, a mental health evaluation of Mr. Rollison?
You know, I talked to someone about that the other day, and I didn't recall that. But then, in trying to go through my mind as to everything that I did or how I handled this case, there's a psychologist in town named Dr. Don Meck that is very well respected here and is used a lot by criminal defense lawyers, also used by district attorney's offices throughout the state to give evaluations. And I did in fact have Dr. Meck go and see Mr. Rollison because I do remember now being concerned, and also because of his age, that I wanted to have someone take a look at it. Dr. Meck is also an attorney. He doesn't practice law, but he is a member of the state bar. That's my recollection. But I had him evaluate Mr. Rollison, and I think it's my understanding Dr. Meck went to the Pulaski County Jail or whatever jail facility Mr. Rollison was at to evaluate him. And an evaluation was done and a report was made, and the report is in the file.
Do you recall the result of the evaluation or what the conclusion was of Dr. Meck?
Well, as far as I remember, that he was competent to stand trial. It wasn't. I don't certainly if Dr. Meck had said that he was incompetent in any way, or I would have pursued it more, but I didn't, because of the report that Dr. Meck gave. And like I say, it's Mr. Ralston has access to that report because it was part of all the documents that we had in this case.
Okay. If the report indicated that Dr. Meck had recommended further evaluation to see if there was the possibility of a delusional compulsion, would you have any reason to dispute that?
I'm not going to dispute anything in Dr. Meck's report, nothing at all.
Okay.
I've got the utmost confidence in it.
Do you recall whether or not Mr. Rollison was then evaluated by someone at the Georgia Department of Behavioral Health and Developmental Disabilities? That might have been pursuant to a court order?
I don't have any recollection of that, ma'am.
Do you recall getting a report from that examiner?
If I did, the record will so reflect.
Okay. And I think you indicated you had discussed this case with Mr. Rollison and got his version of events. Is that a fair statement?
I talked to Mr. Rollison many, many times.
And what defense, if any, were you able to formulate to the charge?
Well, that's a hard question to answer because of the fact that in talking with my client and his mother and his parents, we were not in a position where we had to decide what the defense was going to be. In other words, I guess what I'm saying is that I don't know if we ever formulated a specific defense that was going to be used for this, insofar as this case was sort of on a collision course with trying to work out a plea of some sort. If I'd been placed in a position where I had to come up with a defense or decide a defense or talk to my client about what his defense was going to be, we would have done that, but I don't think that we ever got there.
So if I'm understanding, your testimony was a guilty plea of something that Mr. Rollison was interested in from the outset, or how maybe the better question is, how did the guilty plea come about?
Well, we talked about, and understand, I'm dealing with a 17-year-old young man who was accused of committing a bad crime. I had Mr. Rollison's mother was very ill and extremely emotional about this. Also, Mr. Rollison's parents were extremely emotional about this and the impact that it was having on the family. And understand, Pulaski County is not a very big community. And I've been practicing law a long time, and I'm not one for trying to. I don't mind having jury trials in cases. I also understand the impact that a jury trial can have on my client and my client's family. And a decision was made to try to resolve this case without putting the family, the Rollison family, through the ordeal of a jury trial. I mean, I don't know how else to answer it. I only talked about a guilty plea for Mr. Rollison in connection with trying to, and once again, I'm not the kind of lawyer that's going to tell somebody. A lot of people say, well, what are my chances, lawyer? I mean, tell me what my chances are. You know, I did what I felt was best in that case and advised my clients to the best of my ability. At the time I was representing Mr. Rollison, I'd been practicing law for over 30 years and been involved in 9 death penalty cases and a lot of murder cases. And I wanted to make certain that with the plea that Mr. Rollison was in fact going to, the sentence that he would receive would be a life with the possibility of parole. Now, there's been some controversy about whether or not the state could have thought life without parole in this case. And, you know, that issue still being fought and decided. One was just recently in a case that I'm involved in Houston County. And I just felt eventually it was in the best interest of my client and his family that he enter a plea. But then again, I don't ever tell somebody if they should accept a plea or not. That's what they told me they wanted to do.
Okay. And did a guilty plea was an option that was prominently on the table from the start. Is that a fair statement?
I'm not going to say that.
Okay.
I'm not going to say that. I mean, I'm not going to say that it was something that it was always on the table. I knew it wasn't a death penalty case, and I mean, I wasn't concerned about that. But I mean, Mr. Rollison was 17 years old when this happened. You know, I wanted him to be able to see light at the end of the tunnel. The many people that I represent in cases, ma'am, or in murder cases and death penalty cases, is where a life without parole sentence is something that's horrible to my way of thinking. That the privileges that the prisoner has when they're with the Department of Corrections are. I just hear horror stories about people that are put in that position where they're not able to see or visit with their, I mean, the clients aren't able to see their family. I mean, they're segregated completely from them. And that's another thing that really concerned me. My client's mother was in bad shape physically, and the parents were, I mean, the grandparents were upset. And it means a lot to clients when they're in a position where if they're incarcerated, that they can see their people, and that, and plus that he was 17 years old, and I just believe that there's light at the end of the tunnel for him.
So in that, did you have discussions with Mr. Rollison about a possible life without parole sentence in this case, that it was within the range of punishment?
Well, I told him that, but you know, at that particular point in time in 2013 and a few years afterwards, you know, there's always the talk about, you know, whether or not the court could give someone life without parole on a 17-year-old. And like I say, that the way things are turning out right now, like I say, I'm involved in a case here where a 17-year-old was convicted of murder, and the Superior Court judge here gave a sentence of life without parole to him. I had a co-defendant who was 18. He got life without parole, and the Supreme Court of Georgia upheld that. And there's also a recent United States Supreme Court. And I say all these things because I've always felt that there are, it's not just a simple calculation on Mr. Rolston's case to plea him out and just know for certain that he was going to get a life with the possibility of parole. I didn't want to take that chance with him. Plus, like I say, I don't think that the family wanted to go through the ordeal in that small community of having a jury trial of a crime as heinous and horrific as this one. To have that out in the public eye I mean, like I say, it's just a decision. I mean, I talked to my clients about it. That's what they wanted to do. Everybody was in agreement. You know, if I had to do it all over again, would I do the same thing? I probably would. Because of my concerns with, you know, what happens in murder sentences. And I just felt like, you know, once again, not to keep repeating it, I didn't want my client to go through his sentence thinking that there's no hope or no light at the end of the tunnel. And there is for him. I truly believe that.
So just very briefly, Mr. Groove, you discussed the elements of the offenses with him,
Oh, yeah. Yeah.
and you discussed the range of punishment for each offense with him,
Yes, ma'am.
and you had discussed his constitutional rights that he had and that he would be waiving before he pleaded guilty.
On several occasions.
And did you advise him he had a right to a trial by jury?
Yes.
And did you discuss with him that he had a right to confront witnesses against him?
I did.
And did you advise him he had a right not to incriminate himself?
I did.
And did you advise him that he could not be forced to testify against himself if he went to trial?
I did.
And you had did you examine the indictment in this case?
Yes, ma'am. I mean, you know, like I say, yes, ma'am. In answer to your question, yes, ma'am. I went through it with a fine tooth comb.
I have no further questions at this time, Your Honor.
Any cross-examination of Mr. Groove?
Yes, I'd like to cross-examine the witness.
All right, you may.
Mr. Groove, generally speaking, do you tell your clients not to talk about the facts of the case with anyone outside of your presence?
Yes, I do. Generally, I do. I don't want my clients talking to people on the phone. I don't know who's tapping who or who's bugged who. I prefer they not talk. I prefer they not do it orally, over the phone, in writing. Yes, yeah, I mean,
thank you, sir.
What clients tell me is sacred to me.
Did you advise me particularly not to talk about the facts of this case with anyone outside of your presence?
Ask that question again.
Did you advise me in particular not to talk about the facts of the case with anyone unless you were present?
Well, okay, am I talking to Mr. Rollison?
Yeah, no, anyone outside of my presence.
No, I may have told your mother and your grandparents that I didn't want them talking to them about the facts of your case.
What I mean is, did you tell me to not talk about the case with anyone?
I probably did. I don't specifically know, but I probably did. I tell all my clients that.
Okay, thank you. And in general, do you try to raise only the strongest claims or grounds in a case?
Not necessarily the strongest claims. If I see anything that I think doesn't pass muster, I'm going to raise it. And I did that in your case too.
Okay, thank you.
All right.
But as an attorney, excuse me, go ahead. As
I'm
an
listening.
attorney, is it true that you have a duty to avoid raising frivolous claims or frivolous motions?
I'm not going to raise frivolous claims or frivolous motions. That's not what I meant by what I said earlier. If I feel like there's anything to help my clients, I'm going to raise it. I'm not, there are a lot of lawyers out there that they just don't do their job and won't file motions for fear of being denied or shot down or something. I don't let that bother me.
And to avoid raising frivolous issues, do you thoroughly research a claim before you actually raise it?
Well, it depends on what it is. It depends on what that particular concern is. I mean, I've been doing this long enough to know if it's something that I realize that in order to raise any claims that I think are improper or deserve attention, I'm going to bring those to the court's attention in hopes that if it's a motion that I file and the court denies that motion, I want it on the record so that if we're in a circumstance like we are now, that if the it needs to be raised on appeal, either through the appellate process or the habeas process, that there will be a definition or an indication as to what that issue is. So many times, excuse me, I'm involved in appeals where lawyers fail to raise issues that should have been raised. And some people may say, well, maybe that lawyer thought that was a frivolous issue. I just do it on a case-by-case basis, and I'm not
All
going to
right,
raise them.
thank you, Mr. Group. That answers my question.
All right.
Next question. You testified that you filed around 15 motions as a part of some standard pretrial motions at the beginning of this case. Was that on May 20th or around May 20th, 2013?
I don't know. I mean, whatever. Like I say, I don't have it in front of me. If it was not the fall of 2013, but in May, that I was. I mean, soon after I was retained to represent your interest in this case. I can remember that, like I say, there was some dispute as to whether or not this was going to be a Bleckley County case or a Pulaski County case, and I think I may have even filed some motions in Bleckley and told that it was going to be in Pulaski, and that, I mean, I'm sure that I filed those motions, soon thereafter.
All right, thank you, Mr. Group. That answers my question. So if the record reflects that you filed the standard pretrial motions on May 20th, you would not dispute that, correct?
Whatever the record reflects, I mean, that's, whatever it shows that the clerk of the court marked them stamped, then that's
And
when
if
they're
the
valid.
record reflects, that the general demurs were filed after the indictment was filed, would you dispute that?
I don't file any general demurs unless there is an indictment.
Okay. And do you research the indictment before filing a general demur?
Always.
Do you satisfy yourself that a general demur has merit before filing it?
Like I say, I file a general demur. Some may say that it's frivolous to file one in every case. I don't believe that. I've had Superior Court judges grant a general demur after I filed
That
one.
answers my question, Mr. Brewer.
Okay.
Is the failure of a count to charge a crime a fatal defect?
Say that again.
Is the failure of an indictment or a count to charge a crime a fatal defect?
Well, if the state passes or gets the grand jury to indict a case, I mean, I'm not understanding what your question is, but if they don't charge somebody, I mean, that's one of the purposes in filing a demur is to make certain that whatever the grand jury indicts you on is something that you can be given notice of and can go to trial on. I don't know if I'm answering your question, but
Okay, that's good. Can we pull up Exhibit 1 on the screen? I'd like the witness to view Exhibit 1. That's a certified copy of the indictment in this case.
of course, I can't see. The only thing I see is a picture of me.
Is there a way that we can pull that up, Your Honor?
Referring to responding to Exhibit 1?
Yes, sir. Exhibit 1. No, the petitioner's Exhibit 1.
Has it been tendered already?
No, sir. I'd like to admit it into evidence.
Do we have a method where we could have that?
He didn't get it to us before time.
Yeah, I don't know. We're not gonna be able to just pull that up on the screen.
I submitted the indictment years ago, Your Honor.
Judge, he filed it with a petition. I'm realizing that our copy is not scanned in. We can get that scanned in quickly so that everybody can look at it, and Mr. Peters can assist me with that if he would.
All right.
And Judge, I don't dispute. I mean, if there's an indictment from the Pulaski County Grand Jury on this case, I mean, you know, it's a matter of record, and I can't respond to it because I can't see it, but I don't dispute it.
I think we're about to have it where you can see it on your computer screen momentarily.
So is Exhibit 1, petitioner's Exhibit 1 admitted into evidence?
Well, I don't think it's been tendered up to this point.
It's been served on the court and the district attorneys.
It doesn't mean it was tendered into evidence. Ms. Smith, do you have any objection? If you want to tender it at this time, you may do so.
Does he see you while you're not talking?
No. They have to see me. I want to see what they're showing.
All right, Ms. Smith, I think you're muted.
We have a certified copy of the indictment marked as Respondents 1 that Mr. Peters is about to share. We will tender it, and it would alleviate the need to have Mr. Rollison's copy, which he filed with the petition.
All right, any objection to Respondents 1, Mr. Rollison?
No, sir.
All right, one's admitted.
And Judge, I see the indictment now. It's on my screen.
All right, Mr. Group. Is it true that count 1 alleges no act, omission to act, or conduct?
Count 1 alleges malice murder.
Can you identify any word, term, or phrase in the language of count 1 that alleges an act, omission, or any sort of conduct?
Your Honor, I object to the form of the question. The indictment speaks for itself, and I think we're getting into legal matters as to whether that's even a requirement of malice murder.
I'll sustain the objection. And again, Mr. Rollison, this is a hearing on the allegations that are contained in your petition, so we're going to stick to constitutional challenge you may have. Ask your next question.
Is it true that you submitted the general demur because you believe the indictment alleged no act?
You know, since I don't have the general demur in front of me,
This is the general demur.
right, I don't want to, I don't know if I added anything besides it just being a standard general demur or not. But, I mean, I don't know how to answer that question.
In your understanding of the law, Mr. Guru, is an act or an omission to act a necessary element of crime?
I don't know how to answer that question.
How would you define crime in Georgia? All right, let me rephrase the question. Were you aware that OCGA 16-2-1 subsection A states that a crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention or criminal negligence?
I'm aware that's in the law, yes.
All right, can you point to any act or omission in this indictment?
Okay, now I'm seeing a copy of the general demur. The general demur that I have in front of me, it appears to be just a standard general demur that I filed for, in most indicted cases that I have for the last 40-something years.
Objection. The question, Mr. Grube, is referring to the indictment.
Okay.
Exhibit 1. Can we go back to Exhibit 1?
Okay, I see Exhibit 1. Mr. Ralston, one thing you need to understand is I'm on your side, okay?
Okay, thank you. I was wanting to know, can you point out any words in the language of count 1 that set forth an act or an omission or any sort of conduct?
I'm satisfied under the laws of the state of Georgia that the way that this indictment has been prepared is sufficient to allege and notify you that you were being charged with malice murder, certainly in connection with count 2.
So you filed a frivolous general demur.
I disagree with that. It's not frivolous.
So what is the basis in this indictment of the general demur that you filed? Why did you file the general demur to this specific indictment?
I don't understand the reasoning behind your question, sir.
Did you note that there are any deficiencies in count 1 or count 2 that caused you to file the general demur?
You know, I don't know that we ever had an opportunity to have a hearing on the general demur because of the fact that the case was pled out. You know, had we had a hearing as to the general demur and all the other motions that I filed for you, Mr. Ralston, I could have amended my motions. I could have been in a position where I argued this to the court as to we needed more specificity as far as the indictment was concerned. But I feel as though that I'm satisfied with what I did.
Is it true that the court had a duty to rule on these demurs within a certain time frame?
No.
Is it true that these demurs were never waived or withdrawn?
I never waived them. You never waived them.
Were they withdrawn?
Mr. Ralston, once the plea was entered, there was no need to have hearings on any motions or demurs.
And no hearing was ever scheduled for this demur, correct?
We didn't have a situation, Mr. Rawson, where your motions were heard and then we decided to enter a plea. We decided to enter a plea before the motions were heard.
Can you read paragraph 2 of Petitioner's Exhibit 2?
Right, okay.
Okay, now did you make that claim because you felt that this indictment charged no crime?
I make that claim in every general demur that I file. And once they're heard, I'll argue that to the court. If the general demur is not heard, then I'm just trying to, at that time, Mr. Rawson, I was trying to find out as much as I could about your case.
Did you file a special demur?
I mean, I don't recall. I mean, I may have. I don't think I did. But then again,
would a special demur have given you more information in this indictment?
Possibly. I mean, I don't know. I mean, I don't know. I'm assuming that the district attorney's office provided me with everything that I needed to try your case.
I'd like to admit Petitioner's Exhibit 2 into evidence.
No objection, Your Honor.
No objection? All right, submitted.
No objection.
All right, submitted.
Is it true, Mr. Groove, that these demurs were unadjudicated when I pleaded guilty?
I don't recall any of the motions being ruled on at the time that you entered your guilty plea.
Okay, were these demurs ever mentioned at the plea hearing?
I don't have a copy of the plea colloquy, so I don't know.
Is there any way that we can pull that up? I submitted it as Exhibit T.
Do we have the plea colloquy?
That's it right there. I'd like to tender Exhibit T into evidence.
Any objection? I think you're muted, Ms. Smith. Ms. Smith, I think you're muted.
Petitioner's T is the plea transcript that's attached to Mr. Rawlinson's petition. I would insist that we instead admit our copy, Respondents 3, it's certified, that's what's on the screen, and have our copy admitted in lieu of Petitioner's T, so there's not two in the record.
Right, okay, I agree with that. And that applies also to the previous exhibit. I think it was tendered as petitioner's exhibit, but it's contained within the respondent's exhibit, so that we don't have a multiplicity of the same items. We're going to limit it to respondent's exhibit unless there's something that's not contained within.
Well, Your Honor, in my brief, in both my briefs,
Please don't interrupt me, Mr. Tolleson.
Yes, sir.
If you have something that's not already included in respondent's list of exhibits, then I'll consider it. Otherwise, we're going to stick to what the respondent has prepared to tender here today. Do you have
I have an objection.
Do you have any other questions for Mr. Groovy?
Yes, sir, I do.
All right, you ask him now.
Is it true that special demurs are sometimes filed to gather more information about what the defendant must be prepared to meet at trial?
Sometimes.
Is it true that a sufficient indictment apprises the accused of what he must be prepared to meet at trial so that he may prepare an intelligent defense?
That's the purpose of an indictment, yes, sir.
Is it true that a prejudicial indictment could deter a defendant from going to trial?
I can't answer that question because I've never been a defendant that's been indicted. So I don't know what might be going through my mind. I don't know what was going exactly through your mind.
Could not knowing what the state intended to prove prejudice your ability to prepare a defense for a client?
Judge, we're getting so far down the line in hypotheticals and situations. I think it's more importantly, what did he do in this case and why? And I think we've already covered most of that.
I agree, Mr. Rollison. Again, you need to limit your questions to address issues raised in your petition.
I raised the failure of trial counsel to raise a special demurrer.
All right, we've already covered a substantial part of what you're asking about. Let's move on.
Does count one allege any specific conduct, Mr. Grube?
It alleges that you committed malice murder.
It contains those exact words in there.
There's malice murder in there.
Other than alleging that I committed malice murder, does this indictment descend to the particulars of the conduct?
Judge, I think that's ultimately a question for you to determine. He's trying to get into legal questions there, which are dependent upon the facts, and the indictment speaks for itself. There are legions of cases, and I don't know that having counsel try to do your job is the best way to go about proving whether the claim is valid.
I'll sustain the objection. I agree again, Mr. Rollison, you need to ask questions that are relevant to the issues that you've raised in your petition.
Yes, Your Honor. Does count one allege that any conduct was unknown?
Again, Your Honor, the indictment speaks for itself.
Let's move on, Mr. Rollison. I've got the indictment and I understand your position on the indictment.
Did I ever tell you, Mr. Grube, that my mother and I rented from Mr. Henry Cravey?
No one ever told me that.
You said the name was familiar. Is it possible that we could have talked about Mr. Cravey before the resolution of this case?
I'm going to intervene here. Again, you need to ask questions that are relevant to your constitutional challenges. This is not an opportunity to go back and retry your case.
And you were unaware that Mr. Cravey was actually ineligible to serve on the grand jury. Is that correct, Mr. Grube?
Like I say, any concern with Mr. Cravey was brought up after the case was resolved.
Is it true that you did not investigate the composition of the grand jury or their proceedings?
I don't understand your question.
Did you investigate the composition of the grand jury or any related proceedings?
I made sure that the grand jury passed legal muster and that as far as looking into the history or the background or the social history or whatever of each one of the grand jurors, I didn't do that.
Were you present at any of the grand jury proceedings?
Pardon me?
Were you present at the grand jury proceedings?
I wasn't allowed to be there.
Were you present when the indictment was returned into open court?
No, sir. I wouldn't know when that was returned into open court because I don't know when it was. I mean, the indictment speaks for itself as to when it was presented, and I don't know which Superior Court judge received it. And the clerk of the court would have received it then. But in all my 42 years, I've never had had a district attorney say, I need for you to come to court at 2 o'clock because we're going to bring the indictment in there that charges your client with burglary or something.
Thank you, Mr. Group. That answers the question.
Yeah.
Would you dispute the minute record if the minute record shows that there were no proceedings held on June 24, 2013?
I object to the question, Judge. It assumes matters not in evidence. We've not had anything about grand jury minutes or not being reported in this case.
I'll sustain the objection. And further, the statute requires that the indictment be returned in open court, and it's customary for courts to go into the courtroom and receive the indictments in court when there may not be any other scheduled court that day, and therefore there may not be any minute reflecting that, which is probably what happened in this case.
Your Honor, can I admit the totality of the record that was produced by Michael King in the evidence as Exhibit 28?
Ms. Smith, do you have that exhibit?
I don't, Your Honor. What I would ask is to have the opportunity to see it before it's admitted. If it's a certified copy from Mr. King of the entire record, I would not have any objection to it, but I just unfortunately have not seen it. So I don't, if there's a way for me to be able to do so beforehand, I just want to, if it's certified and he says it's everything, but I can't ascertain that where we are at present.
Well, the only way I know to deal with that is to hold the record open at the conclusion of this hearing and have Mr. Rollison supply you with his tendered exhibit. And then you can respond to it and decide whether or not it's objectionable. You're muted, Smith.
If I could see like the first page, I don't know if they can scan it in there at the prison. I know sometimes we've been able to do that. I think under the circumstances, if it's, I have no objection, Your Honor.
All right. So, and I'm not sure how he's going to submit it, but I'll hold the record open and allow him to tender his exhibits.
Well, are the exhibits, are they tendered?
They're tendered and admitted. The last exhibit that you referenced is tendered and admitted without objection at this time.
And that's the items produced by Mr. King, right?
That's correct.
Mr. Group, is it true that I was 17 years old at the time of the crime and at the time of the arrest?
Yes, sir.
Mr. Group, when you talked about your experience as a lawyer, you mentioned no experience with juvenile cases tried in the Superior Court. Is that correct?
No, sir.
How much experience do you have with juvenile cases being tried in the Superior Court prior to my case?
A lot of experience. Plus, I was the associate juvenile judge for Houston County, Georgia, for the entirety of the 1990s. So I have a lot of experience in handling juvenile cases. Over the years, I've represented several young people, 13, 14, 15, 16, that have been charged with offenses for which they've had to face their consequences in the Superior Court, as opposed to the juvenile.
I believe that answers the question.
Don't interrupt him while he's answering. If you're going to ask him a question, let him answer.
Yes, sir. Mr. Group, can you describe how the Superior Court exercised jurisdiction over my case?
You were 17, and the Superior Court of Pulaski County had every authority at that time to indict you and bring you to trial in the Superior Court of Pulaski County.
Thank you, Mr. Group. Is it true that the jurisdiction was exercised under OCGA 1511-560B1?
Judge, I object to the form of the question. I don't think this is supposed to be a pop quiz on the Georgia Code.
I'll sustain the objection.
Mr. Group, were you aware that the Superior Court would lose jurisdiction over this case if an indictment was not returned within 180 days.
I wasn't aware of that. I don't think that's true.
Are you familiar with 17750.1 subsections A and B?
I mean, I've been using the same law, the Georgia Code annotated ever since it's been in existence. And I, I feel as though that the Pulaski Superior Court had every right, every authority to bring you before that body on a murder case.
And pursuant to their jurisdiction, the Superior Court had to return a valid indictment within 180 days, correct?
I object to the form of the question. It misstates the evidence, Your Honor. The offense of murder is different from the other offenses for which there may be concurrent jurisdiction in the juvenile court and the Superior Court.
I'll sustain the objection.
Prior to my case, Mr. Group, had you researched any cases involving defective indictments and the application of certain juvenile codes such as 17750?
I'm not gonna allow that question. I mean, this isn't any previous case that Mr. Gruby has handled is irrelevant to the constitutional claims that you've raised in your case. Ask your next question.
Were you aware that a juvenile's life sentence is 60 months?
Mr. Rawson, I have no control over what the Department of Corrections does on any sentence, whether it be a life sentence or not. I have no control over that.
To your knowledge, Mr. Groove, what is the maximum sentence that a juvenile court can sentence a criminal defendant?
Object.
Yeah, I think you're muted, Ms. Smith. Ms. Smith, we're not here.
I'm sorry. I object to this entire line of questioning. He's not a juvenile offender being charged with a non-homicide offense. And this whole line of questioning is irrelevant and based on a misunderstanding of the law.
I'll sustain the objection. Sir, you are an adult and you were tried as an adult in Superior Court. This has nothing to do with juvenile court. And we're not going to waste any time on those questions.
How many times have you used Dr. Meg for his psychological services?
3 or 4.
And was my degree of criminal responsibility ever an issue in this case?
I was concerned about that.
And is there any way that we can pull up on the screen Petitioner's Exhibit 3, which is the psychological examination? I submitted it on 5/12/21.
It's on the screen now, Your Honor. Mr. Rollison, we have scanned in your petitioner's exhibits 3, 4, and 5, which are the two evaluations and the ordering the evaluation, just for your information.
Thank you. Did you thoroughly review this report, Mr. Groove?
Yes, I did.
Does this seem to be an accurate copy of the report?
Appears to be.
I'd like to admit Petitioner's Exhibit 3 and tender it into evidence.
Any objection?
Objection, Your Honor.
All right, 3 is admitted.
Is it admitted?
Yes.
Does Dr. Meg's report determine my degree of responsibility at the time of the act?
You know, I valued his evaluation and his opinion, and I don't have any complaints about the language in it. And, I mean, like I said, I don't know what you're asking me. I took his report and gave it the due notice that I needed to in preparing your case.
What was the conclusion of Dr. Mack's report, Mr. Grube?
Like I say, I haven't seen this in years. I mean, I don't have any dispute with whatever conclusion he gave.
And you sent this report to the judge in this case, is that correct?
I don't recall who I gave it to. I don't remember. I don't remember. I don't remember. I don't know if I just gave it to you. I don't know if I just gave it to you, or if I provided it to the court or provided it to the district attorney. I just don't remember.
Is it true that Dr. Mack recommended further evaluation?
Like I say, if you want me to read through the entire report, I will. But whatever Dr. Mack said in this report about his conclusions and what he thought should happen next, I agree with what he said.
Is it true that the court ordered my evaluation as to my criminal responsibility and competency to stand trial?
I don't think that this is something that I did on my own. I don't know that I may have filed I don't recall what I filed, but this is something that I felt very strongly about doing soon after I took your case.
Can we pull up Exhibit 4? Exhibit 4 is a court order for me to be evaluated. Do you have any dispute with anything in this order?
No, and if I had to get the judge's signature to get the Pulaski County Jail to allow Dr. Mack to come in, I see where Judge Mullis signed it. Don't have any problem with that.
This was actually for the state evaluation, Mr. Grube.
Okay, well, I don't have any problem with that either.
And were you present at the state's evaluation?
I don't remember if I was present for that or not, for sure. Sometimes the state evaluators will let me be there or be in a room outside or I just don't remember.
Well, okay, all right. Yeah, well, I'd like to admit this into evidence.
No objection.
All right, submitted. This will be petitioners, what number? 4?
4?
All right.
Yes, sir.
4. Submitted.
Do you recall how this evaluation turned out, Mr. Grube?
I don't.
Can we pull up Exhibit 5? Is it true that I was never evaluated as to my degree of criminal responsibility?
Mr.
Grube?
I have to rely, Mr. Ross, on the exhibits that you presented.
Did you advise me not to be evaluated?
I think I told you, Mr. Rollison, that once Dr. Mack did his evaluation, then the state would have the ability and the authority to have you submit to theirs, and I wasn't going to have you dispute or an order signed by Judge Mullis. I wasn't going to advise you to go against what the judge was telling you had to do.
You earlier testified that you told me not to talk about the facts of this case with anyone unless you were present, correct?
I believe that's what I told you.
And you just testified that you're not sure as to whether you were present at this evaluation. Is that true?
I don't know if I was or not.
But you did consent to Dr. Mack's or Judge Mullis's order, correct?
When the judge passes an order, it's not a matter of whether or not I want to consent to it or not.
Is it true that I could have been taking your advice and not talking to the evaluators because you weren't there?
Object, Judge, that assumes matters beyond his personal knowledge. He can't know what was in Mr. Rollison's mind.
I'll sustain the objection as a cause for speculation. Ask your next question.
If I had a question regarding what the evaluators were asking me, could I have reached you somehow?
I'm certain you could have. I've been at the same office for over 30 years.
So to your knowledge, I had access to communication at this evaluation?
I don't know if you had access or not.
But you don't recall being there, correct?
I'm not going to say that either. I just don't remember.
If you were there, would you have advised me to directly disobey Mr. Mullis's order?
No.
Objection. Oh, sorry.
It's sustained. Ask your next question.
I'd like to admit Exhibit 5.
No objection.
All right, 5's admitted.
All right, that's it for my examination.
All right. Any other witnesses? Ms. Smith?
We have no other witnesses, Your Honor, and just to make sure our tender is complete, I think we've already put up on the screen Respondents 1, which is a copy of the indictment. We tender that at this time.
Any objection?
No, sir.
Submitted.
Respondents 2 is a copy of the sentence.
Any objection?
No, Your Honor.
Submitted.
And then Respondents 3 is a copy of the plea transcript.
Any objection?
No, Your Honor.
Submitted.
And we have nothing further at this time, Your Honor.
All right, any other exhibits, Mr. Rollins?
Yes, sir. I have some more exhibits I'd like to file. Did we ever tender exhibits 0, 6, 7, 8?
And you're referring to petitioner's exhibit numbers, is that correct?
Yes, sir.
3, 4, and 5.
Yeah, we only got 3, 4, and 5. So anything other than 3, 4, and 5 has not been tendered or admitted this time.
All right, and what about Exhibit 2?
Tell me what exhibit?
That was the general demur.
I think that is in.
That's in respondent's record, is that correct?
Well, actually, Judge, it's petitioner's exhibit. We have no objection to it.
All right, so 2 is admitted. What other exhibits do you have?
I have 1A.
Okay, what is that?
1A is a certified document from one of the clerks as to Mr. Cravy's status as an elected official.
And that may be one of those documents that Ms. Smith needs to review prior to making a determination as to whether or not she has an objection.
I submitted these documents a while ago. This is not a part of what was produced by the Dukas Teacom.
Do you have this document, Ms. Smith?
Judge, it's actually filed with the petition, and you should be able to view it in the file itself.
Well, if it's part of the record, I'm not going to go.
It's technically, it's attached to the petition.
So we don't need another copy of it if it's already in the record.
It would be in the clerk's record and not part of the court reporter's transcript of today's hearing. I don't have an objection to it, although to its admission, but I do have arguments as to what it does and does not show. But for for purposes of today, I have no objection, just so it's coming in so you can see. But I don't think it proves what he purports that it does.
All right. So it's admitted without objection.
Also, I have Exhibit 1A1 and Exhibits 1A2. Those are both affidavits.
All right, have those been provided?
No,
Yes, sir.
no objection, Your Honor. They're attached to the petition, but I have no objection. They're two documents from the clerk of the Pulaski Superior Court.
They're admitted without objection.
Actually, Exhibit 1A1 and 1A2 are affidavits that I myself wrote and my mother wrote.
I do have objection. He can test to his own affidavit. He can testify today if he wants to. I also object to the mother's affidavit. She purports to say to give her opinion about why it was improper for Mr. Cravey to have served on the grand jury since she knew her son. I don't think that comes in even under the new rule. I object to it on that basis.
All right, so that would be, I'm sorry, so 1A1 is admitted, 1A2 is not admitted. Is that correct? Or you don't have any objection?
I do have to 1, Your Honor. I mean to 1A1 and I and 1A double I. Those are the I object to those.
All right. And we don't need an affidavit from you, Mr. Rollison, since you're here testifying today. So 1A, 1I, and 2I are not admitted. All right, what other exhibits?
All right. All of the exhibits not admitted, I'd like to preserve them for the record on appeal.
So noted. Any other exhibits?
All the exhibits not admitted, I'd like to still preserve them for the record on appeal.
Okay. All right. Do you have any other exhibits?
I have 1B and 1C. These were statements made from the Superior Court clerk.
Have these been provided to counsel respondent? Ms. Smith, do you know what he's talking about?
I do, Judge. I have no objection to those. Those are the documents I was referring to earlier. They're from the Pulaski Superior Court clerk.
All right, they're admitted.
I'd also like to admit exhibits 6 and 7. These are also documents referring to the population of Pulaski County and the year 2013.
I object, Judge. I don't know the purpose for which they're being offered, and they don't appear to be certified or copies. I think you could take judicial notice of the census, which would reflect what the population was, but again, I don't know what the relevance is.
Your response to that, Mr. Rollison?
These are two affidavits, actually, that certify the correctness of the attached exhibits 6 and 7.
All right. So I will not allow those in. Any other?
I would like to preserve.
Any other exhibits?
Yes, Your Honor, I would like to preserve those for the record on appeal, and also have exhibits W1, 2, 3, 4, and 5, which refer to the service of the subpoenas.
I object on grounds of relevance, Judge. I don't think they prove anything, and I don't think there's been any question about who's here today or whether the clerk provided documents.
All right, so I will not allow those into the record.
All right. Can I preserve them for the appellate record?
My court reporter's taking all this down. It's all going to be in the record.
I also have exhibits 100 and exhibit 101. Exhibit 100 is an affidavit, and 101 is also an affidavit.
Okay, whose affidavit? 100 is an affidavit?
100 is my affidavit, and 101 is my father's affidavit.
I don't appear to have those, Your Honor, and I would object to anything Mr. Rollison can certainly testify as to what he has in that affidavit, so he could be subject to cross-examination. And I don't have the one of his father to which he's referring.
And I think his father is available to testify, so there's no need for affidavits. I'll sustain the objection.
Okay, I also have exhibit. I would like to just preserve the remaining exhibits, 201, 202, 203, and 204, just for the appellate record then.
All right, it's noted for the record. Any other witnesses you wish to call, sir?
No, sir, but I do have an oral argument.
All right, you may proceed.
Your Honor, the biggest issue in this case is that I'm convicted on an indictment which fails to charge a crime. According to Smith versus Hardrick, 266, Georgia 54, this claim isn't waived by any sort of guilty plea. And also count one omits the essential element which renders the indictment void and incapable of supporting the conviction. According to OCGA 1621, subsection A, quote, a crime is a violation of a statute in this state in which there is a joint operation of an act or omission to act, an intention or criminal negligence, end quote. Your Honor, this statute expressly incorporates into every offense, including murder, an act or an omission, also known as actus reus. With this in mind, I'd like to bring your attention to the indictment, Exhibit 1. The arguments on page 3, which we've already looked at, are essentially state, quote, that I unlawfully with malice aforethought caused the death of the victim, a human being. That's the relevant portion of the count 1 that I'm referring to. This count alleges no act, omission, or conduct, and therefore charges no crime. There are no words, terms, or phrase that allege the actus reus element, and the only phrase that could even remotely be considered as the actus reus element is the he causes phrase. Better known as the he causes phrase, the Georgia Supreme Court has already told us in State versus Mondor, 306 Georgia 338, that the he causes phrase represents the element of causation, not the actus reus or any sort of conduct. And now I do recognize that count 1 does track the language of the statute, but it does also omit the essential element of actus reus. So for clarity, I'd like to point the court's attention to the Supreme Court's ruling in Jackson versus State, 301 Georgia 137, which reads, quote, to withstand the general demur, an indictment must, 1, recite the language of the code that sets out all the elements of the offense charged, or 2, allege facts necessary to establish the violation of a criminal statute, end quote. Your Honor, this ruling shows that although an indictment may track the statutory language, it can still be subject to a general demur if an essential element is omitted. So this leaves us with 2 questions. Is the actus reus an essential element of murder? And 2, does count 1 allege an actus reus? As to question 1, we've already seen that the Georgia Code tells us that an act or an omission is necessary for all offenses, including murder. Also, in the Supreme Court's opinion in Daddario versus State, 307 Georgia 179, the court states that, quote, every crime has as elements an actus reus and a mens rea, end quote. So the court here even uses murder as the example, stating that murder, quote, requires that the conduct result in death, end quote. So our statutory law and our Supreme Court answer question 1 for us. Yes, the actus reus is an essential element of murder, and an act, omission, or some form of conduct is necessary to charge murder. As to question 2, does count 1 allege an actus reus? The answer is no. We've seen it with our own eyes that count 1 alleges no sort of general, specific conduct at all. It alleges no act, omission, or anything like that. And to illustrate this fact that count 1 alleges no actus reus or conduct, I would point the court's attention to a similar case. In Hinton versus State, 280 Georgia 811, the body of the victim was never found, and Hinton was charged with murder, and the indictment alleged that, quote, he unlawfully and with malice aforethought did kill, murder, and cause the death of the victim, a human being, in a manner unknown to the grand jury at this time. The court found that Hinton's indictment was sufficient to withstand both general and special demurrers. The count tracked the statutory, the language of the code, and the general words of conduct, kill and murder, were sufficient to allege the actus reus. Hinton's indictment alleged that his conduct of killing and murdering in an unknown manner caused the victim's death. But in my case, count 1 alleges no general conduct or specific conduct or no actus reus. So by pleading guilty, I only admitted that my malice aforethought caused the victim's death, not that my actual conduct caused the victim's death. And because thoughts alone can constitute a crime, this indictment is void and defective. It omits the actus reus element and charges no crime. And according to Smith versus Hardrick, my conviction on this void count violates my 5th Amendment grand jury rights and my 14th Amendment due process rights. And also according to Lozana versus State, 695 SC 2D 208, my due process rights under Georgia's Constitution, Article 1, Section 1, Paragraph 1, were violated because of the omission of an essential element. Also, kind of going towards ground 2, the subject matter jurisdiction claim, Riley versus Garrett, 133 SC 2D 367. Under that case, the indictment's failure to charge a crime left the Superior Court without jurisdiction to enter judgment. The judgment in this case is therefore null, and my conviction violates the 5th and 14th Amendment due process and also Georgia due process. I'd also like to point out the jurisdictional issue and clarify myself with the juvenile jurisdiction. On May 9th, I was arrested and detained for murder. At that time, I was 17 years old. So under Code Section 1511-11-560B, and that is 1511-560B, the Superior Court exercised exclusive original jurisdiction over the case. However, according to Code Section 17-7-50.1, subsections A and subsections B, a grand jury must return a true bill of indictment against a detained child within 180 days, or the court loses jurisdiction and the detained child's case is transferred back to the Superior Court. And now we can assume that this statute means a valid grand jury, a proper return, and a valid indictment. And in this case, there was no valid grand jury, there wasn't a proper return, and there was no valid indictment. According to a juvenile case regarding these issues, and that is State versus Armendariz, 316 Georgia Appeal 394, the return of any sort of invalid indictment doesn't toll the 180. Also, this claim wasn't waived by guilty plea because it's a jurisdictional issue, and the 180 days actually expired on November 26, 2013. So had counsel quashed the indictment due to the juror's incompetency, or for any other reason, after November 26th, the case would have been transferred back to the juvenile court as an operation of law, and I would have faced a maximum sentence of 60 months instead of a 30-year parolable life sentence. I would like this point to be considered in the prejudice analysis and the ineffective assistance of counsel claim. Ultimately here, because the indictment charges no crime and an ineligible foreperson served on the grand jury and the indictment wasn't properly returned, the Superior Court never had the jurisdiction to enter the judgment of conviction and sentence. And this violates my 5th and 14th Amendment due process rights, my Georgia due process rights, and also my right to counsel under the 6th Amendment and Georgia's Constitution. Back to the counsel. Counsel filed the general demurs, but he never enforced a ruling on them. So this whole time that he knew that the indictment was defective, and yet he encouraged and advised me to plead guilty. Because his performance ultimately facilitated my conviction on a count that is void, he was ineffective under Polk v. State, 275 Georgia Appeal 467. His performance violated my 6th Amendment right to counsel and my right to benefit of counsel under Georgia's Constitution, Article 1, Section 1, Paragraph 11. Also, count 1 was actually subject to a special demur requesting more information because a sufficient indictment apprises the accused of what he must be prepared to meet at trial to the end that he may prepare an intelligent defense. And count 1 basically failed to do that. As we've seen in the indictment, it speaks for itself on this. Count 1 alleges no general or specific conduct. Now, in cases where an indictment alleges specific conduct, such as shooting, the accused is informed that the state intends to prove that specific conduct at trial with specificity. In cases such as Hinton, where general conduct is set forth and alleged to be unknown, the accused is informed that the state intends to prove a general form of conduct without specificity at trial. Here in this case, count 1 alleges no general or specific conduct, and it also fails to allege that this omitted conduct was unknown. So basically, this indictment fails to express whether the state intended to prove the conduct either with or without specificity at trial. Not knowing what the state intended to prove prejudiced my ability to prepare an intelligent defense, and I was forced to guess at the state's intention by looking at the evidence. This guess and gamble defense strategy increased the risk of a trial in my case and deterred me from going to trial. For example, had I wrongly assumed or wrongly guessed that the state's intention, or worse, had I been misled by the state's evidence, I would have wasted the defense's resources and I would have been left with an inadequate defense at trial. Counsel's failure to file a timely special demur waived my right to be tried on a perfect indictment. And because his deficient performance prejudiced my ability to prepare an intelligent defense and deterred me from going to trial, the plea was involuntary and counsel was ineffective. Had counsel filed a special demur requesting more information, I would have had an opportunity to prepare an intelligent defense, and I wouldn't have pleaded guilty. I would have went to trial. Several Georgia cases hold that counsel's failure to file a special demur in general won't support a finding of ineffectiveness. One exception is where the indictment's deficiencies were misleading and prejudicial, and in this case they were. The deficiencies here forced me into this guess and gamble strategy that increased the risk of trial, prejudiced my ability to prepare a defense, and deterred me from trial. So under Russell versus United States, 369 U.S. 749, This indictment violated my Fifth Amendment right to an indictment by grand jury and my Sixth Amendment right to be placed on notice of the nature and cause of the accusation. My Fifth and 14th Amendment due process rights were violated, and my Georgia due process rights were violated because the indictment unfairly deterred me from going to trial, rendering the plea involuntary. Also, my Sixth Amendment right to counsel and my Georgia constitutional right to benefit of counsel was violated by counsel's prejudicial failure to file the special demurrer. Also, we've talked about the elected official. The indictment was void because the elected official served as the foreperson. At the last evidentiary hearing, Mr. Cravey testified that he was a local elected official during his time of service as a grand juror. And I'm claiming that this claim wasn't waived by the guilty plea because ultimately, as we'll see, the guilty plea was invalid. Also, under Georgia's habeas corpus statute 9-14-42B, I'm specifically allowed to raise this claim upon a showing of cause. And this showing of cause has two requirements under Fountain versus York, 237 Georgia 784. And those requirements are, quote, 1, justification of the failure to raise jury composition questions in a timely fashion, and 2, a showing of actual prejudice. I'm justified to raise this claim now because I did everything that I could to raise this claim timely. I told my lawyer that I believed that Mr. Cravey was an elected official, and my lawyer admits that he failed to investigate and challenge any of the grand jury proceedings or the composition of the grand jury. According to State versus Dempsey, 290 Georgia 763, Cravey's presence rendered the indictment void. His presence was automatically prejudicial as it led to my conviction on a void count. Also, his political influence over the rest of the jurors, whether he recognized it or not, did have an effect. It allowed the state to prosecute me on a void, defective, and prejudicial indictment. And according to Russell, 369 U.S. at 749 at 771, the Fifth Amendment guarantees me a grand jury of peers that is free from government and political influence. Clearly, OCGA section 15-1260B, subsection 1, was designed to protect that fundamental right. In this case, Mr. Cravey's political influence basically swayed the grand jury and allowed the state to continue their prosecution on a void, defective, and prejudicial indictment. And had these jurors not been swayed by Mr. Cravey, they wouldn't have returned such a flawed indictment. The illegal composition of the grand jury violated my Fifth Amendment grand jury rights and my due process rights under the Fifth, 14th Amendment, and also Georgia's Constitution. So after I told counsel that Mr. Cravey was an elected official, he basically should have at least investigated the grand jury and filed a motion to quash. Had counsel filed the motion to quash, a favorable ruling would have likely bolstered my resolution to go to trial. And, I wouldn't have pleaded guilty, I would have actually went to trial. So his failure to file a motion to quash constitutes ineffectiveness and violates my Sixth Amendment right to counsel and my rights to benefit of counsel under Georgia's Constitution. Now, I recognize that there are some conflicting precedents here. In Biggums versus State, 296 Georgia 267, and alternatively cited 765 SC2D 917, the Supreme Court of Georgia found that counsel's failure to file a timely motion to quash based on juror incompetency was not prejudicial. They came to this conclusion because the state could have re-indicted. Biggums, in this whole entire line of cases that Biggums rely on, presents an issue of conflicting precedent. Because in the context of Strickland's prejudice analysis, these cases based their findings of no prejudice on the hypothetical assumption that absent counsel's deficiencies, the state would have exercised its discretion to re-indict. However, the Georgia Supreme Court in Langlands versus State, 282 Georgia 103 at 106, explicitly states that, quote, prejudice is determined on the basis of what the lawyer did or did not do, not what the trial court may have done if the lawyer had performed effectively, end quote. So when analyzing prejudice under Strickland, Langlands found it error to consider how the trial court or the prosecution would have exercised discretion had counsel been effective. So under Langlands, it's likewise error to base a finding of no prejudice purely on the assumption that had counsel been effective, the prosecution would have exercised its discretion to re-indict. So Langlands conflicts with Bigham's to the extent that Bigham's allows hypothetical uses of discretion to be assumed and relied on for prejudice analysis, and Langlands holds the exact opposite. I'm arguing that Langlands correctly upholds Strickland because it limits the prejudice analysis to the current proceeding and doesn't consider any sort of hypothetical future proceedings. But in my brief, both of the briefs, the supplemental and the regular brief, I argue the prejudice of counsel from both standpoints. Also, the indictment is void up under Sugar versus State because it wasn't returned into open courts and entered onto the minutes. Now, the indictment and the certified copy that we've seen, it asserts that it was returned into open court on June 24, 2013. But Mr. Cravey testified that he was the one who filled in the date in that section where it alleges the indictment was returned. So this assertion was made by an ineligible foreperson. It also was contradicted by the very stamp of the court. The stamp on page 1 of Exhibit 1 shows that the indictment wasn't properly filed and entered onto the minutes until January 7th, 2015, which was actually after the conviction in this case was final. I subpoenaed the minutes of the Pulaski Superior Court for the alleged day of return, June 24th, and I haven't had a chance to review those documents, but I believe that the minutes don't exist. Exhibit 1B and Exhibit 1C, and that's petitioners' exhibits 1B and 1C that were already admitted. Basically, the clerk concedes that there are no minutes on the record for that day. And I'm saying that if the indictment was truly returned into open court, then the minute record would support that fact. But here, the minute record, according to the clerk, does not. This improper return violated my Sixth Amendment right to a public trial and my Fifth Amendment grand jury rights, and also my due process rights under the 14th Amendment, the Fifth Amendment, and Georgia's Constitution. Counsel's failure to file a timely plea and abatement violated my Sixth Amendment right to counsel and my right to benefit of counsel up under Georgia's Constitution. This claim, and that's the claim that the indictment was void for the improper return, I'm raising it in its individual capacity because, again, the invalid plea didn't waive this claim, but I'm also raising it in the context of ineffective assistance of counsel. I'm saying that counsel should have filed a timely plea and abatement to quash the indictment on this ground, and from the totality of the circumstances and in light of cumulative error, I believe he was ineffective for failing to do so. And for the principal reason that this indictment was actually void and quashable in 4 different areas. The indictment charges no crime, so it's subject to a general demurrer. The indictment lacks the specificity required by the Constitution, and so it's subject to a special demurrer. The ineligible official served as a grand jury foreperson, that subjected the indictment to a motion to quash, and the improper return subjected the indictment to a plea and abatement. Counsel, I'm claiming that he was ineffective because had he investigated this case and strategically staggered and raised these claims, it's reasonably likely that 2 indictments against me would have been quashed and the state would have been barred from further prosecution on the mutual charges of those indictments. For example, had counsel filed a special demurrer along with the general demurrer, and had he procured a timely ruling on it, it's pretty likely that the state would have re-indicted within the same term of court. And that is with the same grand jury, and that is rendering the subsequent indictment subject to that motion to quash. It is also likely that had the first indictment been quashed, whether it been by the demurrers or motion to quash, that any subsequent indictment would have also been void because it would have still been improperly returned into open court and subject to the plea and abatement. Also, it is likely that this case would have been transferred to the juvenile court under Hill versus State, 309 Georgia, Appeal 531. Also, now going into the issues with the plea and the voluntariness, the U.S. Supreme Court in Brady versus United States, 397 U.S. 742 holds that, quote, a valid plea is entered voluntarily, knowingly, and intelligently, end quote. I'm claiming that this plea wasn't. According to Brady, the standard for voluntariness is that the plea be entered by one fully aware of the direct consequences. And under Gay versus State, 342 Georgia Appeal 242, the court held that the maximum possible sentence is within the direct authority of the trial court, and it must be considered as a direct consequence of entering the plea. This plea was involuntary because the court affirmatively misrepresented the maximum possible sentence of the malice murder charge. We've already took a look at Exhibit T, and we see on pages 4, lines 10 through 13 that the court says, quote, so you could, if we proceeded on both counts, you could receive up to life in prison plus 10 years. Do you understand that? End quote. On line 14, I responded, yes. Your Honor, this interaction shows that I wasn't fully aware of the maximum sentence, because the maximum sentence in this case was actually life in prison without the possibility of parole, not just life in prison. Also in North Carolina versus Alford, 400 U.S. 25, the court held that the standard of validity of a guilty plea is, quote, whether the plea represents a voluntary and intelligent choice among the alternative courses of action open to the defendant, end quote. Here, I was unaware of the following courses of action. I was unaware that I could have, 1, enforced the general demurrers, or 2, that I could have asked for a directed verdict of acquittal at a trial. Because this indictment charged no crime, these were the only 2 logical courses of action, and counsel's failure to rule on or have the demurrers enforced and ruled on by the trial court stopped me from taking this course of action, and that is enforcing the demurrers. Also, the plea was, this renders the plea unknowing and unintelligent. Again, the plea was involuntary because the indictment's lack of specificity and counsel's failure to file a special demurrer prejudiced my ability to prepare a defense and deterred me from going to trial. The Brady court also held that for a plea to be knowing and intelligent, the accused must have, quote, sufficient awareness of the relevant circumstances and likely consequences of the plea, end quote. The transcripts reflect the fact that I was unaware of the following circumstances. Obviously, I was unaware that the indictment charged no crime. I was unaware that the court neglected its duty to decide the demurrers, and I was unaware that counsel had actually failed to enforce the demurrers. Also, the plea was unknowing and unintelligent because I misunderstood the nature of the charges. On pages 3 and 4 of Exhibit T, the court read both counts of the indictment aloud. However, the court only asked me if I understood the affirmatively misrepresented consequences of the counts, not if I actually understood the charges themselves. The psychiatric report that I've submitted as Exhibit 3 and the state's factual basis given in the plea transcript showed that I didn't understand the nature of the malice murder charge, because I didn't understand that my mind state at the time of the crime could not support what I was pleading guilty to. Also, the psychiatric report shows that I was suffering from a delusional disorder at the time of the crime, and the state actually concedes this point in the factual basis. On page 9, lines 22 through 23, the state says that I, quote, began to view people as being computers or something of that nature, end quote. Your Honor, if I couldn't distinguish a person from a computer, then I couldn't distinguish right from wrong. The transcript, the psychiatric report, and the record as a whole support the fact that I misunderstood this charge because I wrongly believed that my mind state, which is viewing people as computers at the time, could support murder. The trial court and my attorney both had duties to ensure that the plea was voluntary, knowing, and intelligent, and the trial court's acceptance of the invalid plea violated my due process rights under the 5th and 14th Amendment in Georgia's Constitution, Article 1, Section 1, Paragraph 1. Counsel's failure to ensure the plea was voluntary, knowing, and intelligent essentially violated my 6th Amendment right to counsel and my right to benefit of counsel under the Georgia's Constitution. The only claim that I'm raising under a strict light of due process is the trial court's affirmative misrepresentation of the maximum sentence. And I'm raising that just under due process, not ineffectiveness. Lastly, the trial court abused its discretion, erred, and caused a manifest injustice by accepting the plea for several reasons. Again, if we look at Exhibit T on page 8, lines 21 through 23, we see that the trial court actually accepted the plea prematurely before the state actually gave the factual basis. This shows that the trial court either, one, expected the state's factual basis to be sufficient, or two, the trial court was actually relying on unspecified portions of the record to make the determination. In either case, an abuse of discretion exists because the factual basis given afterwards is actually insufficient, and reliance upon unreferenced and unspecified portions of the record for a factual basis is an automatic abuse of discretion. The factual basis is given on pages 9 and through 11 of Exhibit T, and I'm claiming that it is insufficient to support the charge because, again, on page 9, lines 22 through 23, the state concedes the fact of my mental state at the time of the crime, and they concede that I was under some delusion where I began to view people as being computers. Again, this doesn't support the mens rea required for murder. This really supports an insanity defense because someone who can't distinguish an inanimate object from a human being clearly is incapable of distinguishing right from wrong. Furthermore, the court recognized that this delusional mind state was not solely manifested by my drug use. The court actually acknowledges that my age was also a contributing factor to this delusional mind state. On pages 18 and 19, lines 25 through 27, the judge stated, quote, "I'm told that the human brain is not fully developed until a person reaches about 24 or 25 years old. Putting into your unformed brain things like LSD or whatever else you did impeded that growth and resulted in the epic tragedy that we have here today," end quote. The judge made the wrong decisions because the facts that he accepted as true did not constitute what was charged. And this all could have been avoided had the court properly determined my competency at the time of the act, or had I been fully evaluated as to my criminal responsibility at the time of the act. The trial court was well aware of my competency, and it was well aware that the competency was an issue. Again, we've already established some of this, but on April 16, 2014, that's when I was evaluated by Dr. Meg, who is a certified forensic psychologist. He concluded that, I was experiencing a delusional disorder, and Dr. Meg recommended further evaluation of my criminal responsibility. This report was sent to the judge. He references this report in his order, and the order that he entered was for me to be evaluated as to my competency to stand trial and my competency at the time of the act, and that's Exhibit 4. The state did their evaluation on 8/15/2014, and they found me competent to stand trial, but my competency at the time of the act was never evaluated. I declined that evaluation because my attorney was absent and he hadn't advised me on the matter. In fact, he advised me not to talk about the events of the case unless he was present, and he wasn't present at that day. Before the court accepted my plea, my criminal responsibility should have been fully assessed and determined at some sort of court hearing. And ultimately, the court's acceptance of the plea created a manifest injustice because it resulted in a plea that was not voluntary, knowing, and intelligent, and it wasn't made with the benefit of counsel, especially in regards to the competency evaluation done by the state. These things violated my due process rights under the 5th and 14th Amendment, and also under Georgia's Constitution, Article 1, Section 1, Paragraph 1. And also my rights to counsel were violated under the 6th Amendment in Georgia's Constitution. Now, Your Honor, I'm gonna wrap this up, and I'm just gonna ask for the relief. An incompetent grand jury illegally returned an indictment against me which charged no crime. Counsel, he filed the general demurs, but he failed to enforce a ruling on him, and he also thwarted my efforts to be mentally evaluated. Instead of representing me, he actually cut off my only avenues of defense, and that was the general demurs and the competency evaluation. Yes, this is a guilty plea. I pleaded guilty, but my decision to do so was not voluntary, knowing, and intelligent. I didn't understand the nature of the charge. I thought that my delusional mind state could constitute murder, but I was wrong. The court affirmatively misrepresented the maximum possible sentence, and I was unaware of the relevant circumstances and alternative courses of action of this plea. Also, I was denied effective assistance of counsel, and the court created a manifest injustice by accepting the plea. Again, the biggest issue here, and it's the one that's easiest to see, is that the count 1 alleged no actus reus and it charges no crime. And this sort of violation demands an immediate and unconditional release. In all the relevant cases, such as Smith versus Hardrick, 266, Georgia 54, the Supreme Court affirmed the petitioner's writ because he was sentenced on a fatally defective and void indictment. And for that reason, the court ordered that he be discharged from his present state of incarceration in Stanton. Also in Henderson versus Hames, another habeas case, 697 SE 2D 798 at 804, the court found the indictment, quote, void for failing to allege an essential element of felony murder, end quote. The court affirmed the grant and held that the petitioner, quote, should be released from prison, end quote. Because my indictment lacks an essential element and charges no crime, I stand in the same position as Hardrick and Hames, and I'm asking for the same relief deemed appropriate in their cases, and that is immediate release from prison, and also ask for any other relief deemed appropriate by this court for all the other grounds. I'd like to thank everybody for the opportunity to be heard. I know that I'm not a lawyer, but I tried my best with this case, and I pray that this court comes to a fair decision.
All right, thank you, Mr. Rawlinson. Ms. Smith, obviously, I'll give you the opportunity to respond. Due to the length of the presentation, I'll give you the opportunity at your election to submit a brief that addresses each of these points after a transcript's been prepared.
I was going to ask that, Your Honor. I admit he's got a couple sophisticated issues. They're important. I want to get them right. The juvenile issue, we actually have that pending in a habeas case in the Supreme Court. I know that the law looks at the juror disqualification issue differently if you're raising it pretrial versus you didn't timely raise it prior to and had a trial, and certainly in a plea situation. But I think these are important issues, so we would appreciate the opportunity to submit a brief.
All right, and same, Mr. Rawlinson, I'm going to give you the same opportunity to submit a supplemental brief after the transcript's prepared, 30 days within receipt of transcript. All right?
Thank you.
Thank you, Ron.
I'll consider the brief and get an order out to you. That concludes the hearing. I think that concludes the calendar. All right, Ms. Smith, you and Mr. Peters, it's been a pleasure to be with you virtually today.
It's good to see you, Judge. Glad you're well.
Everybody's good. Y'all take care. Be safe.
Thank you.
Thank you.
All right, bye-bye.